Our feet are like this far from the ground, both of them are like swinging.
Yeah, I'm gonna do it. Okay, I think are we ready to go? Just about, okay. Oh, she's fine. You'll give me the thumbs up when we're good. Okay, we're good. Welcome back, everyone. We're now going to move to agenda item number 5, housing capacity analysis rule update. Thea and Madi, you'll take it from here. So we'll turn it over to you, and thank you very much.
Great, thank you. Good morning, Chair Halova, Vice Chair Lilac, and members of the commission. For the record, my name is Thea Croman. I'm a housing policy analyst, and I'm here to provide an update to the housing capacity analysis schedule. This is an annual update to maintain the accuracy of the schedule. So you'll be hearing from us about this rulemaking every year. I'm joined by my colleague, Madi Valencia Aguilar, who will be presenting briefly on the housing production strategy following rulemaking. So annual revisions to the HPS menu of tools, actions, and policies is usually a part of this annual update. But the housing team has recently contracted with fair housing experts, including our very own Commissioner Lazo, to work on a new module to better support local governments to meet their fair housing obligation under the HPS program. So this is still in process, and Madi and Commissioner Lazo will tell you more about that following the hearing. But because this is a public hearing about rulemaking, I wanted to focus on that first. So the purpose of this presentation is to present, review, and adopt updates to the Oregon Administrative Rule, Chapter 660, Division 8, Section 45, describing the housing capacity analysis schedule, which was originally adopted by this body in November 2020. As a reminder, nothing from rules and Division 8 is changing. We're simply conducting a routine update of the information within Attachment A. And as we noted last year, this agenda item for LCDC will be part of an annual update that the housing team will bring for Division 8 rules. As new cities adopt housing capacity analyses, cities move ahead of or behind their noted schedule, and changes occur in housing policy. These updates from the housing team will reflect just our current tracking of the HPS program. So in light of this, we request that the commission take action to vote to adopt the Division 8 attachment. We'll provide some sample language for how you might state that at the end of this presentation. Just a real quick reminder here about HB 2003, and you all know this pretty well at this point, so I'll keep it really high level. The first part of HB 2003, the ONA, the Oregon Housing Needs Analysis, is a regional calculation of housing needs, taking into account housing dynamics across jurisdictions, as well as a shared responsibility across Oregon's regions for housing production. And obviously, since the passage of HB 2003, the ONA and its implications for Oregon's housing production have really expanded immensely, particularly given legislation this current session. But I just wanted to lay that groundwork. The second part of HB 2003 is the housing capacity analysis, which was a report that was historically completed as jurisdictions had resources and capacity. So nothing has changed in the manner in which cities complete this. It's just the frequency of the analysis, which is every 6 years for cities within Metro, every 8 years in cities outside of Metro. Cities with populations of over 10,000 must now submit the document that considers housing need over the 20-year planning horizon. The HCA has to take into account PSU's population projections and needed housing based on those projections, as well as buildable land, income distribution within the jurisdiction, as well as measures to accommodate needed housing, including efficiency measures and UGB sufficiency. HCA, okay, I mentioned the schedule, so 6 years within Metro, 8 years outside of Metro. The final part of HB 2003 is the housing production strategy, which is on hold for the moment as we develop a really exciting tool that Mari will tell you about soon. So attachment A here is the updated schedule for cities over 10,000, which reflects, again, cities that have chosen to adopt their HCA ahead of schedule, cities that have fallen behind schedule, and cities that have reached the 10,000 population threshold in 2022. A real quick note about deadlines here. The deadline is December 31st of any given year. Failure to adopt an HCA by that deadline will result in sort of the beginning of this tree of enforcement. So the first step is collaboration and support. It's a state partnership to establish a schedule, locate and overcome barriers together. After that, jurisdictions will enter an intergovernmental agreement outlining specific compliance actions. Failing that, DLCD can withhold technical assistance and grant funding, and finally move to an LCDC issued enforcement order. We hope to live in sort of number one here, and so far so good. So this is difficult to see. Hopefully you can read it in your packets. This is the most up-to-date schedule. This is attachment A of agenda item 5 in your commission report. Note here that the first 4 housing capacity analyses were due to the agency by December 31st of last year, 2022. 3 of the 4 did not make that deadline. And those are the ones that you can see here in red. So this is a new process, and we anticipate that we'll continue to really need to provide support and accountability as cities come on board. Recognizing that some jurisdictions really struggle with capacity issues and some simply need more handholding. So far, they've been largely receptive to working with DLCD. These delinquent cities are all on a modified schedule now to complete their housing capacity analyses in 2023 and are within their rights according to OAR. So we're just working with them, not terribly concerned at this point. Also note that thanks to generous technical assistance in the last biennium, some cities adopted their HCA prior to the listed deadline. So you can see those here in green, if you can read it. They effectively reset the clock so that their next HCA deadline will fall 6 or 8 years after their early adoption, depending on whether or not, again, they're within the boundary of Metro or not.
May I speak to the previous slide just
Yes.
briefly, commissioners, just for to connect a couple of things that we've already talked about today. Earlier in the director's report, we looked at key performance metrics and talked about the housing plans being just a tiny bit behind. That's what you're seeing here. And so those two conversations are linked. Thank you.
Definitely. So in addition, each year on December 15th, PSU's Population Research Center publishes new city population projections, which allow DLCD staff to assess which jurisdictions have reached the 10,000 population mark. At the end of 2022, one brave city surpassed the 10,000 mark, adding them to the HCA schedule. So welcome, Sweet Home. Per rule, cities have 2 years to produce their HCA once they've been certified at 10,000. But Sweet Home was anticipating this transition had the assistance of a technical assistance grant from DLCD and is prepared to adopt their HCA this year. So you can actually find them on the schedule for 2023. So thank you, commissioners. That concludes this part of this presentation. I'd just like to pause and take any questions from commissioners before we move on to public comment.
Thank you, commissioners. As well as online. I can't see you, so let us know if you have a question online.
Vice Chair, this is Chair
Halava.
Halava. It's like, how do I refer to myself? I had a question. It was just curiosity. You said some of them adopted it early, the ones in green. What did that mean as far as like actual timing? Was that because it was due December 20th last year? Does that mean
December 31st? Yeah.
31st? How did they do that early? I was just trying to understand that.
So Chair Halava, thank you for the question. Mari, do you want to, I jump in there? I'm not sure exactly technically.
Yeah, in terms of Chair Halava, Vice Chair Lilac, thank you for the question. I believe I should say, for the record, my name is Mari Valencia Aguilar. I'm a housing planner. Yeah, the cities that are adopting early were either, as Thea mentioned, granted a technical assistance grant from our office to support their HCA work ahead of when they were listed on the schedule. And so because they'll be adopting early, we were able to update that schedule to reflect reflect them in a more current schedule based on that earlier work that they did, as opposed to just where they were in the schedule originally.
Yeah, and it's not really significant to the work. I was just thinking, was that earlier in 2022, or was that like they did it in 2021 or 2020, like some just not even a part of the schedule that we've set now? Because if I'm understanding correctly, like cities were supposed to be doing this work, but kind of weren't on this more rigorous schedule, let's just say. So when we say early, I'm just curious. Yeah, it's just for my edification. Yeah.
Chair Halava, thank you for the question. So if, for example, in our adopted schedule for 2022, Salem was originally scheduled to adopt their housing capacity analysis in 2024. So that is a couple of years earlier than what it was before.
Okay, so it's set on the schedule that they were supposed to be doing before, and if they just did it earlier than that, then it just the whole schedule got reset. Okay,
Exactly.
Thank you. Thank you.
Thank you. Any further questions, Chair? Hearing
None.
Thank you. Any others, Commissioner Gibson, that you can see online? I'm not seeing any. Commissioner Boyer.
Barbara Boyer, I had the same exact question as our chair, so thank you.
Any other questions from the commission? No.
Yeah, I guess now that I'm thinking about it. And so after you do your housing capacity, then 1 year after your HPS is due?
Yes.
Is that correct? Okay. I guess I know what I'm confused about. I was just looking at Gresham, for example. So Gresham's not due for their HCA until 2027, but I noticed that they're doing their HPS in 2024. So I guess that means that they did their HCA in 2022. I think I understand now that this is where I was getting tripped up.
That's correct, Chair Halava.
Okay, thank you.
Please.
Yeah.
Just know they're doing that. I know they're doing that work right now. So that's why I was like, oh, they don't. I was trying to understand the schedule. Thank you.
And Chair Halava, Vice Chair Lilac, members of the commission, just to clarify, because this is a kind of weird statute that is confusing and takes a minute to wrap your head around. One thing, just a quick clarification on the HPS, it's not just 1 year after your housing capacity analysis is complete. It's the year after it's due.
Right.
That's what's specified in the statute. So
I
so
see. Thank
for
you.
Salem, if their due date for the HCA is 2024, their due date for the HPS is 2025.
Okay,
It's not due a year from now. If that makes sense.
thank you.
Thanks for that clarification.
Thank you. Other questions or comments from commissioners? I just want to, I'll make just a couple of comments. One, I really appreciate the approach of collaboration, and hopefully, as you said, you kind of live in that space, and just given the need for housing supply across the state, I would expect a lot of, if not most communities, all cities would want to do this work in order to then lead to housing production. I see the three that are in red. I'm not going to make any comments other than the fact that Newport has presented to us a couple of times about some of the great work that they're doing on so many levels in the city, as well as experiencing staffing shortages. So certainly understandable to see why, you know, some cities may be in these situations. So thank you for your collaborative work with them. This is certainly important for all of us. Any other comments or questions? Commissioner Boyer.
Barbara Boyer. So the ones in green, I like seeing the success, you know, you see the red, but it's really nice to see green too. But did I hear you right saying that all of these that are in green did apply for the technical assistance grants?
I think that they did. I think that that's. Yes, yeah.
Okay. So that
Yeah.
speaks to the
Chair-
technical
Chair
grant.
Halava,
Yeah,
Vice Chair Leland, Commissioner Boyer, yes.
it just speaks to the technical assistance grants and the success of it. So I just wanted to highlight that. Thanks.
And if I may, Commissioner Boyer, yeah, and you know, the technical assistance grants, the next biennium starts in June of this year. So we could see, I mean, we're going to open up a new bucket of funding for jurisdictions to help them or to support them in their housing planning work. And so we could see a lot of jurisdictions kind of shift in their schedule just because of that reason, right? That they're securing these grants to support this planning work. So.
However, can I actually add something else? Well, it's great that they're jumping on this and we really do want them to take advantage of the technical assistance grants. It sort of skews their process because the HPS deadline does not move along with the early adoption. So they could become, certain jurisdictions could get into a circumstance where they're sort of having to rush one piece or the other to stay on a schedule. In the next cycle, it will all reset so that it's together. I'm slightly fuzzy on this, so please correct me if I'm wrong, but we generally want them to stay on the schedule that's sort of noted if possible.
I was certainly pleased to hear about more buckets of funding
Yes, money's good.
to help support the work. Do we have anybody signed up to provide testimony on this item? We do not. Vice Chair Leland? Yeah, Commissioner Lazo.
Thank you, Vice Chair. I just had a question. I think I want to go back to the three cities listed in red. Is it fair to characterize, I think quite often what we hear from cities is it's a capacity issue around completing some of this work. Is it safe to characterize it that way?
Yes. I'd say
Okay.
so.
And so I'm also wondering, in the work that we're so deeply involved in now around the Oregon housing needs analysis, it will fundamentally change the way that this process works, and might shift some of that burden away from these cities. And so what years is 23? So 3-4 years from now, we might see a very different dynamic in this process. Is that I think where we're headed potentially?
Commissioner Lazo, thank you so much for the question. I would have to agree with you, right? The ONA and my colleague Sean might be better here as the lead on that project, but essentially it is a restructuring to support local jurisdictions and a lot in their HCA work. And so that lift does get removed. and offered to in support to do housing planning. So spot on, great comment.
Any Commissioner Warren?
And just a follow-up question about the funding. I think it'd be useful for all of us to know what are the size of these grants that are going out to the different jurisdictions, and maybe just generally how much money do we have available just to help maybe promote that program?
Commissioner Warren, thank you for the question. I should know this. I want to say, and my colleagues, either Ethan or Sean, if you can come and support us here, that would be great. I will say that the bucket of funding could always be large. I'll just hand it over.
Commissioner Warren, that's a great question. For the record, my name is Ethan Stuckmeyer. I'm the Senior Planner of Housing Programs here at DLCD. So in the past two biennia, the 2019 to 2021 and the 21 to 23 biennia, DLCD has received $4.5 million in each of those to fund technical assistance programs. And I ran the numbers a while ago, and I think that funded a total of 130 projects on an average of about $65,000 per project. And we're happy to report that every jurisdiction that has requested funding has received at least some of their requests. So
that's great news.
Also adding to that, for the next biennium 23 to 25, the department's requesting $2.5 million to support this work.
Yeah, and Commission, for the record, my name is Sean Edging, Housing Planner at DLCD. I'll add that in addition to that $2.5 million for the continued implementation of Goal 10, we're requesting additional resources to facilitate kind of urbanization related work. We have a request specifically for $1 million to do that, as well as resources for rulemaking. Our job kind of next biennium is going to be outlining a variety of kind of off-the-shelf methodological and policy options for local jurisdictions that support housing production, affordability, and choice. So we have a lot of work ahead of us, but presumably this is a major priority of the legislature, so we would anticipate definitely support going forward.
Thank you. And you both may just want to stay with us for here. Commissioner Jacobson has her hand raised.
Hi, thank you. I had a follow-up question on these grants. What's sort of the difficulty level and capacity that it takes to actually go after one? And I ask that because I just feel like local governments oftentimes lack that capacity. And I feel like it's a part of accessibility that we don't always maybe recognize, is that while there might be resources on the table, if it's very difficult or very cumbersome to get that resource or manage that resource, and it's not actually a resource. So I was just hoping you could talk about that. I will say in general, DLCD's access to funding, in my opinion, is fairly accessible, but I just wanted to check on this particular one. Thanks.
Yeah, Commissioner Jacobson, it's a good question, and one that we've actually worked pretty hard to try to address in this current biennium. We structure the grant program in two different ways. One is a direct grant straight to the local government so that they can do their own procurement process and hiring of a consultant or staff to work on a project. We also provide a DLCD provided consultant element to that. So DLCD has through an RFP hired a series of consultant teams to deploy on behalf of local governments, which removes administrative burden from those local governments to manage those grants. What we've heard throughout the course of the last two biennium is that system works really well, and it gives flexibility to local governments to choose how they want to engage. However, we've also heard that just the application itself is really difficult for those single planner staff communities. So we actually have a meeting in 2 weeks with our grant team here at DLCD to work out some of the ways that we can streamline that process even more for those local governments in the future.
Yeah,
Great, thank you.
Thank you very much. And Commissioner Jacobson, any other follow-up questions?
No, thank you.
Okay. Thank you. Great discussion. Any other comments or questions from commissioners? I'm not seeing any. Any final comments from staff before we consider a motion? No, thank you. It's been very, very helpful. Would anyone like to make a motion on this item?
I will. I move that the Land Conservation Development Commission adopt updates to the attachment in Oregon Administrative Rules, Chapter 660, Division 8, Section 45, as drafted in Attachment A of Agenda Item 5.
I second. Barbara Boyer.
Thank you. Any discussion on the motion? Here at the table or online? Seeing none, Jan, will you please call the roll?
Commissioner Lazo,
Aye.
Commissioner Sandoval,
Aye.
Commissioner Jacobson,
Aye.
Commissioner Boyer,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lilac,
Aye.
Chair Halova.
Aye.
Great. Thank you very much. Concludes our work. Thank you for the presentation and for the whole team's support. We really appreciate it.
And at this point, I would like to hand the mic over to Mari and invite Commissioner Lazo up to this side of the dais to tell us a little bit more about the exciting work that they're doing with the housing production strategy.
This is new. Yeah.
Chair Halova, Vice Chair Lilac, members of the commission. Again, my name is Mari Valencia Aguilar. I am a housing planner with the Department of Land Conservation Development. This portion of the presentation is not one that you'll take action on. But as Thea mentioned in her presentation, typically at the annual update, we would also be presenting any updates related to the housing production strategy menu of tools, actions, and policies. However, we have recently initiated an exciting partnership with consultants to help us make updates to the HPS menu, which I'll get to in a moment. However, I just want to provide just a brief overview of the housing production strategy program, which wasn't presented in Thea's segment of the presentation before kind of getting to that piece. And it looks like I did have a PowerPoint. It was in the same PowerPoint slide deck that Thea's was on. So I'll just continue talking about the housing production strategy program. And really what the HPS is that final step in the housing paradigm under statewide planning goal 10, housing. One more right there. Perfect. It's the final icon that was on, I believe, Thea's fourth slide here. And as we've mentioned earlier, this housing production strategy report is required to be produced by local governments right after 1 year following their housing capacity analysis adoption deadline. And essentially what this report is a game plan that articulates various strategies that a city will take to meet their identified housing need as stated in their housing capacity analysis. Reports are submitted to our office and we are reviewing and approving them. There is a midpoint requirement where cities must reflect and evaluate the progress and the effectiveness of their strategies. They're reviewing how well they're working at that either 3-year mark or the 4-year mark, depending if they're on the 6 or 8-year mark, 8-year track based on whether they're a metro city or a non-metro city. And they're saying, and they're really just saying, okay, these are working, these are not working, and they're allowed the opportunity to course correct, because the ultimate goal there is to ensure that they are meeting all the housing needs as identified in their housing capacity analysis. Over rulemaking, the housing production strategy menu of tools, actions, and policies was developed. This tool was a list that was crowdsourced. It's got an amazing list of tools that support housing production, and the housing team organized the list of strategies under these categories, which you see on the slide here. Cities can reference this HPS menu as they're working on their housing production strategy report, and choose from a combination of these strategies to ensure that they're meeting all their housing needs. The last point that I'll make on the housing production strategy report, last but very important requirement, is that the collective strategies included in their HPS report must achieve fair and equitable outcomes as they relate to the 6 factors that are listed here on this slide. And that takes me to the exciting message about our new partnership that the housing team has formed with our very own Commissioner Lazo and his organization, the Fair Housing Council of Oregon, and Dr. Andre Tremolay with Commonwealth Consulting, 2 fair housing experts in our very own state who are helping us apply a fair housing lens to the HPS menu, and hopefully produce a new module to support local governments meet their fair housing obligation under the housing production program. And so with that, I will turn it over to Commissioner Lazo to tease you all about this exciting new project.
Thank you so much, Mari. For the record, I'm Alan Lazo. I'm the Executive Director at the Fair Housing Council of Oregon. And as folks have seen throughout the meeting, I'm also a commissioner here on LCDC. And I'm going to start by providing kind of a great deal of context about how vital this work is that we are entering into, specifically around fair housing. And folks who know me and know my work, that's absolutely the world that I live in almost all the time. And the perspective that I bring to almost everything that I do in this work. And particularly, it's how I entered the work. And 3 or 4 years ago, in talking to folks that were doing housing planning work in our state, one of the things that folks who have heard me talk about this before, that really struck me was how divorced the housing planning we were doing as a state was from the work that we were doing in fair housing. Much of the work that I had done previously actually didn't take place in this building. It took place across the street at OHCS, at the Oregon Housing Community Services, the Housing Finance Agency. It was all about federal compliance, which is in part what fair housing is about. But what we're seeing right now is that there's a national movement to really recognize what fair housing and the fair housing movement is about. Just this last week, we saw the federal government release new rules around proposed rules and regulations around affirmatively furthering fair housing. And one of the really critical pieces that happened was the federal government actually renamed the plan that the local cities are required to do to produce around fair housing from what was called an analysis of impediments to fair housing before to an assessment of fair housing, is now retitled as an equity plan. And that really captures, I think, what we are trying to accomplish in the fair housing movement, and as we marry it to housing production in our state. And I love that Sean is so good at boiling down the work that they are doing into 3 words right now, right? Production, affordability, and choice. So we know that we're leading with production, and that the issue we're trying to address in this state is the need for production to end the housing crisis that every community in our state is impacted by. And so I'll circle back to that, but it's that 3rd word around choice and how we come to equitable choice that is the roots of what we're trying to accomplish with this work here. We also, I think we're really honored to see it specifically called out in the governor's executive order around housing production. The 3rd bullet point around making sure that we are not only producing housing, but producing in a way that is spatially equitable and reaches our obligation to affirmatively further fair housing. So HUD and the federal government defines affirmatively furthering fair housing as a requirement for federal fund recipients to not only not discriminate in housing, but to take meaningful, and I always like to add there, proactive actions to overcome segregation and to create and further inclusive communities in those communities that receive federal funding. I think that there is some discussion as to who falls under that obligation, whether or not it's just HUD federal funds or if it's all federal funds. I think what we'd agree, though, is that every single community in our state, whether or not they receive those funds, has a desire to have equitable outcomes in their housing in their communities. And so the work that we're looking at in the expansion of this toolkit is really making that connection between the production of housing and those fair and equitable outcomes. The toolkit that was developed as HB 2003 moved forward was really a list of strategies that jurisdictions can choose from on a menu to ensure that they are reaching their production goals. What we really want to do in addition to that is make sure that those goals, as they're being selected, are also being connected to issues around equity, so that we're not just producing housing, but producing it in a way that has equitable outcomes. And I'll give you an example of that. You could go into that list and say, we're going to put into place a construction excise tax. We're going to incentivize affordable housing in these ways. The critical question would be, how is that addressing racial segregation in your community? So the first thing you need to make sure you're doing is understanding what racial segregation looks like in your community, and then understanding from that toolkit which of the strategies might actually help address that and in which way. So it's making that connection inside the toolkit to ensure that tools and strategies that are being selected are connected to the issues that they're intended to address, beyond just the first 2 points that Sean makes, beyond just production and affordability, but also how does it address choice in which ways. It's a little bit harder to measure, I'll admit that, but nonetheless, it's an important aspect of the work I think we're trying to accomplish with where we're headed as a community, as a state, I think as a country. As we do this work, I'm partnered with, we're actually a very small part of the work on this work, where it's actually mostly being done by Dr. Andre Tremolay. We're looking at tools that from a national perspective, so evaluating what other folks are doing at that national, federal level of affirmatively furthering fair housing, and also looking at other examples in places where they've put in place at this level obligations around affirmatively furthering. We saw it at the state level in California, and there are some tools that have come out in places like that that are really a good template for how we might proceed. The last piece I'll recognize is that I talked to Dr. Bateman about this, that I often, when I'm traveling around the country and talking to my colleagues in fair housing, I have to remind myself of the opportunity that we have in this state to move this work forward. That's not true everywhere. And so I think it's a real testament to be able to do this work at the state level in the way that we are right now. A real testament to who we think we are as a state and as communities throughout that state. So, happy to entertain questions about what the work looks like.
And commissioners, one last note that I failed to mention in my piece was we'll be bringing the updated HPS menu at a later time before your commission. So you'll get to see the exciting final product this year, just later, as we're just continuing our partnership with Dr. Tremolay and Commissioner Lazo.
Thank you very much. Great to hear about the housing capacity and then now the housing production. So it's great to have these presentations back to back. We just have a couple of minutes before we begin our Yamhill County piece, but let me turn it over to commissioners, and Commissioner Sandoval.
Okay, great, thanks. Yeah, in terms of fair housing, to what extent is economic development associated to that? So I'm thinking about minority-owned businesses. So like in the Housing Council, we're really focusing on that now, and building the capacity for minority-owned businesses and, you know, developers and so forth, especially in rural communities, because there's just not, the numbers are not there. And so I'm wondering, I understand fair housing in terms of not discriminating, but housing is also, like we mentioned earlier, an economic development tool, right? So so is there anything around that in that framework, or would you see that as something different?
Vice Chair Lilac, Commissioner Sandoval, thanks for the question. And if you gave me the rest of the day, we could spend it talking about it. But my brief answer to you is, I think, especially with affirmatively furthering fair housing, when we talk about the term inclusive communities, we recognize that it means much more than just housing. The nice thing is the team at VLCD has given us a little bit of latitude in the toolkit to say, yeah, let's talk about, are there other pieces that would be involved in that? The example would be, for instance, that an area, it's about community development, as you know, right? So an area that is not just about building housing there, but about what investments would we make in a community to make sure it's an area of opportunity, for instance, right? And so that's not just about housing, it's about other economic development opportunities. I think some of them are outside the scope of particularly the housing production strategy, but from our end, from the Fair Housing Toolkit, I think we want to make sure that we're recognizing that those aspects exist. Again, I'm not sure that how they'll be reflected in the tools and strategies, but we want to reflect that there's a holistic approach that particularly for communities, we need to recognize.
Thank you. And online, Chair Halava or Commissioner Jacobs?
I had my hand raised. I just wanted to point out that it's really great to see this moment that we're in, because I remember when we were, Commissioner Lazo and myself were on the housing production strategies rulemaking, and I remember we didn't have a federal government that was supportive of what we were writing at that time. And I remember we were like, oh, should we actually write these words affirmatively furthering fair housing, when they had just said they don't want to talk about those words anymore at the federal government. So I'm glad to see like we said, this opportunity at the state to stick with this, right? And now the federal government has come back to it. So I just wanted to point that out. We're the leader in that regard. And then, I think Commissioner Lazo, you would understand this tension. I think that's different in Oregon than in some other states that have a large, let's say, minority population in certain, let's say, neighborhoods or portions of the city is kind of that, Oregon being, predominantly white. I think choice is an important word in this regard, because anytime we talk about like segregation and stuff like that, it doesn't apply the same way to our state, in the sense of we have more of a tension between, I guess, segregation and gentrification than I think other places have. And so the ability for people to have the choice to live in neighborhoods that are culturally supportive of their community, and also the choice not to live, to live in communities where they are the minority, right? So I think that choice is important, because if you just looked at it from a segregation point, you'd say like, let's stop, let's go toward people not having the choice to live in culturally significant neighborhoods. And I think that is an issue that we face, like in, let's say, displacement in Northeast Portland. It's like, if somebody from outside didn't understand the mechanics, they would say, oh, it's good, it's not segregated anymore. But really it's the choice, because people are not having the ability to live in the neighborhood that they want. So I think that also goes toward schools and people being able to move to areas which are supportive of educational advancement. And that goes to choice. So I think we can never forget the huge linkage between housing and educational advancement, given the way our system's set up. And I'm just saying one more thing. The author of Color of Law, who wrote about discrimination in housing, is very interesting that he came to that topic through an education lens. That's how he came into that. So I wanted to point that out, that we shouldn't forget that, because that leads to the future prospects on economic development are actually start with education, and then weirdly they start with where you actually live.
Mm-hmm.
Thank you, Chair Holova and Vice Chair Lilac, if I might add. Chair Holova, I agree with you 100%. And I think what we're cognizant of in the work we do in fair housing is making sure that we're not actually defining what choice is when we use that word. And I think as we're asking cities to do that in jurisdictions, we ought to be asking them the same things. I don't think that we are looking at a toolkit that defines it, but ask cities to recognize what it might look like on a local basis, because it is different in every community in this state. And so part of the HPS also calls on community engagement, and that might be the kind of place where we ask, what does choice look like in your community, and what have been barriers to it in the past? And it speaks also to Commissioner Sandoval's point is that choice might include economic opportunities where I live now, rather than me moving to an area that has economic opportunity. So it looks very different in very, very different places. And we do trust that folks in local jurisdictions know their communities and know what they need.
Thank you very much. Any other comments, Commissioner Halava or Commissioner Jacobson online? I'm not seeing any.
No more
Uh,
comments from me. Thanks.
Great. Thank you very much. We'll now move to agenda item number 6. I'm not sure if this is going to be in person or online or a hybrid, but this will be Hillary Foote, and I'm not sure if Gordon is also participating in the presentation. Maybe it's Hillary. Great. Thank you. So Hillary, I'm happy to turn it over to you.
Great. Good morning. For the record, Hillary Foote, Farm and Forest Land Use Specialist for the Department of Land Conservation and Development. So thank you, Chair Halova, Vice Chair Lilac, and Commissioners. So this morning, the staff is here to request Commission approval of an appeal of Yamhill County Ordinance Amendment G-02-22. So the purpose of the hearing today is for the Commission to decide whether to approve or deny this request based on a set of factors, one or more of the factors that are set forth in Division 1 of our rules. And so I'm going to provide some background and context for this case, and then I'll go over those set of factors for decision for the Commission's consideration. David, can you help me advance the slide? While we're working that out, let's know that this is working. Oh, there we go. So the matter at hand is related to implementation of Measure 109, which is codified in Chapter 475A of statute, which authorizes and directs the Oregon Health Authority to create and implement a program for the regulation and licensing of the sale, manufacturing, and administration of psilocybin. And while the Oregon Health Authority has been very busy doing a number of rulemakings to create and implement this program, they do not have authority over those components of the program that are related to land use matters, particularly a question here, those components of Chapter 475A that deal with psilocybin and exclusive farm use zones. There are a number of parallels and similarities between the psilocybin program as it's laid out in statute and the marijuana program that we've become familiar with. And particularly in that set of statutes that describe the relationship of the psilocybin program with exclusive farm use zoning. So the similarities, both cultivation of psilocybin producing fungi crop and marijuana are considered farm use under the definition 215-203. There are certain prohibitions on uses in conjunction with marijuana crops and psilocybin crops. And there are key differences. And one of the biggest differences is that there are no retail sales of psilocybin.
So if I want to adjust psilocybin, I need to go to a licensed psilocybin service center. And that would be administered to me by a licensed administrator under that program. So a psilocybin service center is a really key component of that program. And that's a big difference with the marijuana program where retail sales of marijuana are permitted. So while the marijuana statutes, now we're going to talk about commercial activities in conjunction with farm use. So the commission may remember the Farm and Forest report. There was a section on commercial activities in conjunction with farm use. It is a distinct use that is authorized in Chapter 215, the exclusive farm use statutes, as a conditional use, a type 2 use subject to a farm impacts test. There's a large body of case law behind commercial activities in conjunction with farm use. And there are a wide variety of uses that get permitted as commercial activities in conjunction with farm use. So marijuana statutes prohibit a commercial activity in conjunction with farm use with a marijuana crop. So what that means is only farm product processing facilities can be approved for marijuana. So that's a type 1 use that's allowed outright in Chapter 215, subject to a set of standards that are in 215, 255. There are no education or training facilities as commercial activities in conjunction with farm use for marijuana. There are no events or tasting facilities as commercial activities in conjunction with farm use for marijuana. In the psilocybin statutes, there is a similar prohibition where it says that, you know, there cannot be commercial activities in conjunction with farm use associated with the psilocybin producing fungi crop, except, and this is important, so I'm going to read the language of 475, 573, except that the operation of a psilocybin service center may be carried on in conjunction with a psilocybin producing fungi crop. And so that piece of language in statute 475A that has caused, that has created some ambiguity around implementation of the program. So over the summer, the department received a number of requests for guidance and clarification on those particular statutory provisions from a number of different counties. We consulted with our policy team and with the Department of Justice, and we came up with a statement articulating our interpretation of those statutory provisions, which essentially is that commercial activities in conjunction with farm use in association with a psilocybin producing fungi crop are not permitted unless it's a psilocybin service center. So no large processing facilities that don't meet the farm product processing standards, no education or training facilities as commercial activities in conjunction with farm use for psilocybin. We shared that statement of interpretation with AOC, with a number of counties who had reached out to us. We had conversations with the Oregon Health Authority about that interpretation, and also with Healing Advocacy Fund, who's one of the primary psilocybin advocates about that. We also submitted that statement of interpretation into a number of ordinance amendment proceedings as comments from the department. So somewhat like marijuana, counties also had the option of either opting out of the program or adopting time, place, manner, land use regulations for psilocybin manufacturing and service centers. A number of counties, majority, did choose ultimately to opt out of the program. That program is currently effective in 11 counties in the state. A number of counties adopted time, place, manner ordinances that chose to explicitly not allow psilocybin service centers in resource zones. And this is important. There are 5 counties where the program is effective that have not adopted any time, place, manner ordinances. And several of those counties are fairly large counties. And so there is no formal indication of how those counties may be choosing to permit psilocybin service centers in exclusive farm use zones. Okay. So relevant to this case, there are 2 counties in the state that have adopted time, place, manner ordinances that explicitly allow psilocybin service centers in exclusive farm use zones. So Deschutes is one of those counties. They recently adopted ordinances that clarify psilocybin service centers may be reviewed as commercial activities in conjunction with farm use in exclusive farm use zones or as a home occupation, subject to licensing by the Oregon Health Authority in exclusive farm use zones. And we coordinated closely with Deschutes County staff on development of their ordinance. We submitted comments and we participated in their hearings. And yeah, at the end of the day, staff does believe that the Deschutes County ordinance amendments to the exclusive farm use zone is consistent with law. The other county that has adopted ordinance that permits psilocybin service centers in exclusive farm use zones is Yamhill County. And the difference here
Vice
is
Chair, is it possible to
Yes.
ask a question just because it's on the other slide?
Yes, Chair Halava, please.
If you could go back to the other slide, please.
certainly.
Sorry, it's a very simple question, I think. Does this mean that according to this chart, that only those 2 counties will have service centers, or is there other locations that service centers can be?
So this conversation is limited to exclusive farm use zones and how these types of facilities might be permitted on lands that are designated under that zoning designation.
Okay, so they could be on a completely different zone. This is just,
Yes.
okay.
And
And
thank you, Chair.
okay,
Hulbert.
so the top one where it says opted out and the bottom one and the middle one says prohibited, that's only in, it could also be in relation to other zones, but for the purpose of this slide and conversation, it's only relation to farm use.
Thank you, Chair Halova. Let me just clarify, but for the counties that opted out, those counties have opted out entirely of the psilocybin program in all zones.
I see.
For the
And
11 counties where the program is effective, I've been following efforts to adopt ordinance amendments, paying particular attention to resource zones and how their ordinance amendments are considering psilocybin service centers in resource zones.
Okay, and then the last one, no ordinance filed. Can you explain again what that means?
So these are counties where the program is effective, but they have not filed any ordinance amendments or outlining time, place, manner regulations with the Department of Land Conservation and Development.
Okay, thank you.
And so it's unclear in those counties, Chair Halova, how they might react to an application for a service center in an exclusive farm use zone without that approach codified in ordinance.
Okay, so kind of the first thing opted out is like a different world than the 3 below it, because they opted out completely and then the 3 below it opted in, but the 3 below it are just in relation to resource land.
That's correct, Chair Halova. So for those counties that opt out, whether it's temporary and they might allow the program in their counties in the future, they've completely and entirely opted out of the program. For the 11 counties where it's effective, the information presented here is really related to the treatment of psilocybin service centers in resource zones.
Okay, thank you.
Mm-hmm. All right, so the difference with Yamhill County's approach to authorizing service centers in exclusive farm use zones is that they have listed service centers and processing of psilocybin as new standalone conditional uses in exclusive farm use zones in their ordinance. And the department finds this problematic for a number of reasons, some related to agency authority, some related to application of some well-established case law. But the primary reason and the heart of the concern really is that uses in exclusive farm use zones are limited to those uses that are set forth in Chapter 215 of statute. So 215-203 clearly states that only farm use and those uses that are listed in 215-213, 215-283, and 215-284 are permitted in land that's been protected under exclusive farm use zoning. And as the commission may remember, agricultural lands that's protected under exclusive farm use zoning, that zoning is meant to be restrictive. It's meant to protect that land for agricultural operations. And there are a number of benefits that were conferred onto owners of that land in exchange for those restrictions, like the special tax assessment, exemption from new special assessments, right to farm laws, etc. So really, this approach to allowing service centers as a new standalone use, staff or department sees it as really undermining the key regulatory infrastructure that implements statewide planning goal 3. So that's a bit of the context and background for the issue at hand. So now I'll go over the factors for consideration for decision to appeal or deny the request. And the commission need only find one of these factors to apply in order to support a decision to approve the request for appeal. So the first factor is whether the case will require interpretation of a statewide planning statute, goal, or rule. And in this case, I think it's very clear it involves the interpretation of ORS 215-203, Goal 3, and their relationship to Chapter 475A of statute. The next factor for consideration is whether a ruling in the case will serve to clarify state planning law. And this is a factor that I feel is particularly important, given, as they mentioned earlier, that there are several counties that have not adopted time, place, manner regulations. And clearly there is a difference of interpretation between the department and Yamhill County, and a decision or opinion from the courts on this interpretation of those provisions of 475A, 570 will help clarify how counties should move forward with processing these types of applications, providing certainty and clarity across the state. The third factor is whether the case has important enforcement value. And in this case, the department believes that Yamhill County's ordinance amendment misinterprets that relationship between ORS Chapter 475A and the exclusive farm use zoning statutes in Chapter 215. We believe that interpretation undermines a fundamental principle of the Goal 3 program and the regulatory schema that implements it. The fourth factor for consideration is whether the case concerns a significant natural, cultural, or economic resource. And Oregon's agricultural lands policy, as it's articulated in ORS 215-243, fairly clearly states that agricultural lands are an important physical, social, aesthetic, and economic asset to all of the people of Oregon. In this particular case, has to do with the development of uses on those lands. The fifth factor for consideration is whether the case advances the objective of the state agency's strategic plan. So I think we touched on this in our November commission meeting as well. The current strategic plan and the draft strategic plan that's currently in development both cite as a primary goal the conservation of Oregon's natural resources, including farm and forest lands. And the last factor for consideration is whether whether there's a better way to accomplish the objective of the appeal, such as dispute resolution, enforcement proceedings, or technical assistance. So in this case, again, I think it's fairly clear that there's a difference of opinion in interpretation between how Yamhill County has chosen to interpret those statutory provisions and how the department interprets them. And that an opinion of the courts is going to really help clarify everything for everyone. So in sum, I just want to be clear, very clear, that our goal here is that Measure 109 implementation goes smoothly, and that the land use decision process functions as it is supposed to, so that an applicant who brings a proposal for a psilocybin service center in an exclusive farm use zone in a county where that's permitted, that their application is based on those clear established conditional use criteria, and that this open legal question around process doesn't become a stumbling block for them. All right, so with that, I'll wrap up. I'm happy to take any questions from the commission.
Thank you very much. And so we'll have a moment of clarifying questions from commissioners, and then we'll hear from Yamhill County. So questions from commissioners here or online?
Happy to let others go first. I have a couple of them. And I don't know if this is pertinent or if it's semantics, but and it really wasn't in the materials, but can you characterize what these facilities are like? I guess because you're I think you're talking about like where they would grow the mushrooms, right? And so I don't know what that facility looks like. And then there's also a service center connected to it. And I'm assuming that's where treatment takes place by the licensed folks. And so it could be like somebody's house or an office, right? But what about the grow facility, and how does that compare to a marijuana operation, for instance? And again, I'm not sure it's a consideration that needs to be considered in part of this, although it provides some context to some of the other factors, I think.
Thank you very much for the question, Commissioner Laszlo. I think that's important to understand the different sort of uses that are allowed under the program. So the first is the cultivation of a psilocybin producing fungi crop. And the statute is very clear that that's supposed to be considered a farm use as it's defined in 215-203. So that's the same as marijuana. So the cultivation of a psilocybin producing fungi crop is a farm use. There's no contention or question about that. The Oregon Health Authority does have a suite of rules that clarify, the conditions that those growing operations need to be maintained in, and they have a licensing process for those operations. And so those considerations are not particularly germane to this conversation. So the next sort of bucket of uses is processing of those fungi to extract the psilocybin, and processing of that psilocybin into edible products. So this is something where there shouldn't be much question. There was a lot of conversation about that during implementation of the marijuana program. As far as what can happen in an exclusive farm use zone, there is a type 1 use. It's called farm product processing. It's allowed outright in farm zones. It's subject to a number of standards like square footage limitations and the percentage of crop that's produced on farm versus brought in from elsewhere. And those standards are codified in statute in 215-255. So then the third aspect of the psilocybin program that is very different than marijuana, once it's produced and processed into something, it will be sold at retail outlets. That can't happen for psilocybin. Psilocybin can only be consumed at those psilocybin service centers under certain conditions. And so that's the big main difference. And so the psilocybin program fundamentally depends on those service centers as the places where psilocybin is consumed. It can't be consumed anywhere else. Having sat in on a number of ordinance hearings, including at counties that ultimately chose to opt out, expect that psilocybin service center permits will be contentious, and they have the potential to be contentious in resource zones where they're permitted. Oregon Health Authority does have a whole suite of rules that govern the conditions for operating a psilocybin service center, including, security cameras and separation from residential facilities, et cetera. Oregon Health Authority recently adopted those rules at the end of December. And so there was a lot of uncertainty in the timing was really bad in implementation of the program. So I hope that answers your question, Commissioner.
It does. Thank you. Yeah. So I appreciate those 3 levels. And then also the reminder that the service center for psilocybin is different in that it's consumed on the premises and is guided, I think, by the professionals. I'd forgotten that was part of different than the retail marijuana pieces. Thank you. I have another follow-up question if I could. And I don't think it's for Hillary, but it's potentially for Steve. It says in here the kind of whether or not there's a better way to accomplish the objective of the appeal. It says there's no other alternative method. Is there no other method than appealing the Yamhill County decision? So since we are in contention with what Yamhill County is contending, for instance, could we issue an enforcement order rather than appealing to LUBA and asking them to decide? I'm assuming that would be sort of on the same pathway at some point, right? Those things would just come to head at a LUBA appeal, but are there other ways for us to assert that the difference that we're asserting?
Commissioner Lazo, we couldn't do an enforcement order. There's set out provisions in statute that form the basis for enforcement order, and kind of a sorting it out with the county isn't one of the things to do. So in order to have maybe future conversations with the county, it was necessary to file an appeal. And if they were interested in it, we could suspend the appeal and have those conversations short of filing a record and pursuing it at LUBA. But it was necessary to take that step in order to make sure that further conversation could either occur directly with the county, or if that wasn't something that everyone agreed to, then kind of having LUBA help sort out the what the law on this is, because it's a whole new area of law.
Thank you. I'll just ask you. Oh, go ahead.
Great. So yeah, I have a more of a general question. I'm trying to understand what form, like the difference between kind of industrial agriculture and whether that's still considered farm use. So for example, in Eastern Oregon, they have these large warehouses where they grow mushrooms. They're like right near the city. Sometimes I think inside the city, or I'm not sure how that is, but is that still considered farm use? Is that land?
Thank you for the question, Commissioner Sandoval. So yes, there's a definition of farm use at 215-203. And it's quite long, it's quite lengthy, and there's actually quite a bit of case law around that definition as well. And so indoor agriculture is also still considered farm use under that definition. So whether it's aquaponics or greenhouse operation or the cultivation of legal mushrooms, that's still considered a farm use.
Thanks.
Thank you. Any questions online from Chair Halava or Commissioner Jacobson?
I just, and this is Chair, I just wanted to circle back around to, I don't think it's related. It's not related to this case, but it's going to fully encompass my question of where this can occur. I asked it before, I'm going to ask it again. is there any restrictions with the new regulations on land that these service centers can be on or can't be on? Or is it all lands unless a county decides otherwise?
So thank you, Chair Halova. So if a county wanted to restrict the location of service centers to certain zones, they would need to adopt time, place, manner ordinances, clarifying that they are not permitted in certain zones.
Thank you.
Thank you, Chair. And I'll just ask one question and then we'll move to the Yamhill County. Have you heard this question or similar questions from other counties, whether they've opted out, they've adopted ordinances, they haven't done anything yet? Is the department receiving similar clarifying questions from the department about this issue?
So thank you, Vice Chair Lilac. Yes, we received numerous requests over the summer for clarification and guidance on interpretation of 475A 570, particularly sub 2 and sub 3. And this summer, particularly because counties needed to move forward with filing ballot provisions for opt-out in the August to September timeframe. And so a number of counties then also started ordinance proceedings in case those ballot measures were to fail.
Great. Thank you. Just given the time, I suggest we move to Yamhill County and for their response. And I think that they'll have 10 minutes, if I'm correct. So I welcome Yamhill County to the meeting, and we look forward to your presentation and discussion.
Good morning, Commission. Can you hear me?
Yes, thank you.
Hi, my name is Jody Gallahan. I'm an assistant county counsel with Yamhill County. I have Ken Friday here. He's our planning director.
Hello.
Please excuse my background. I don't want to blur it out because then you can't see Ken. So with that, just go for it, or you tell me when.
Oh, please proceed.
Okay. Thank you for allowing us to provide testimony here today. The letter submitted by our Board of Commissioners lays out our position on the DLCD appeal of our ordinance, and I believe you all got a copy of our letter. Please correct me if that's wrong. Our ordinance does allow for psilocybin service centers as a conditional use on EFU land when it is done in conjunction with the active production of the psilocybin crop. So I just want to be clear on that point. This is not a standalone use. It has to be done, service centers have to be done in conjunction with the crop. Okay, so given that, I do want to make 3 points here today. First, I would like to put on the record that the county never actually received a copy of the DLCD staff report as we were promised in the January 9th letter. We've only saw it for the first time here today after I pulled it from the commission's website. So I do want to make note of that. Second, I'd also like the record to reflect that the county was told that no public testimony would be taken today during our hearing. However, it did appear to me that the public comments that were received at the beginning of the commission's hearing were in relation to our agenda items specifically. And so I want to just make note of the fact that the county received numerous requests from the public to provide comment on our behalf today, but we asked them all not to out of respect for the commission's rules and procedures. Had we known better, we would have directed them to speak during the public comment period. Third, I want to reiterate the fact that the county's ordinance was written to address the requirements of 475A 570, which I believe staff touched on in our presentation. However, it seems DLCD seems to want to disregard that statute in its entirety. ORS 475A 570 explicitly prohibits the county from approving psilocybin service centers on EFU land as a commercial activity under ORS 215, explicitly and clearly. Now, DLCD might want the provisions of ORS 215 to supersede that language, but that is not how that works. Per ORS 475A 570 subsection 3, Psilocybin service centers are allowed on EFU land when done in conjunction with the psilocybin crop. That is the only avenue for approving these things on EFU land. That is the law, and its intent is as clear as can be. Lastly, I want to be clear that DLCD has never provided the county with lawful guidance nor a legal analysis of any kind for their interpretation that 475A 570 does not allow for psilocybin service centers on EFU land. The only guidance received by the county was a single emailed comment received back in September, which it's very important to note here, included a blatant misinterpretation of 475A in that they recommended approving service centers as a home occupation, which 475A explicitly prohibits. We were also told that OHA would provide guidance on this issue within their forthcoming rules. That never happened. As such, the county passed its ordinance based on its own legal analysis of the statute, which was done thoughtfully and with much input from our public, from our community members. We ask that you acknowledge the legal flaws in the staff's interpretation of 475A, recognize the public support that we have received for our ordinance, and honor our county's autonomy by withdrawing the LUBA appeal. And with that, I will answer questions.
Thank you very much. That was certainly well under the 10 minutes. I certainly appreciate it. Let me look to our commissioners here in the room and online for questions. Please.
Barbara Boyer. So you had mentioned the public comment this morning. Did you hear it? Or did you just see the list of the sign up list?
I heard them. I heard the public comments, yes. And we actually over here at the county received emails, or at least 2 emails from individuals wishing to provide public comment this morning. I did forward them to the commission staff member. So I don't think they got on the list, but it is.
Thank you.
Yeah.
And we did have people asking us during the week if they could comment, and it was told to us, and I think it was on the agenda, that no public testimony was going to be taken on this item.
So I think I'll quote you by saying much public comment. Can you kind of give me a rough estimate of what that was? How many?
In terms of our ordinance or today's
No,
hearing?
you just said public, lots of
Support?
public comments.
So we received much public support for our ordinance. I don't know how much public requests for comments we received for the hearing today, because they don't go through me, but
And I don't recall any testimony being given, in opposition to it. There was testimony from friends about how it should be done, but I don't recall anything that was presented to us that we shouldn't go forward with this.
yeah, there was work sessions that I believe Friends was involved with. We really did try to take everybody's considerations into drafting.
Commissioner Jacobson has.
Oh, please, Commissioner Jacobson.
Actually, you inadvertently answered my question in answering the last question about the public process you use. So thank you. No further questions.
Commissioner Lazo.
Thank you, Vice Chair. This is a question for the Yamhill County folks. I just want to make sure that I'm understanding your contention, and it seems like it's deeply rooted in what is actually stated in 475A, right? That 475A actually seems to say that it supersedes 215. I mean, it just like literally says that.
Correct.
And so that seems to be what the contention is here.
Yes, that
And
is.
you're following what 475A says. You said that it supersedes 215. So. Go ahead, I'm
And
sorry.
yes, so just to clarify, we understand DLC's position. It was our interpretation that we could not approve a psilocybin service center as a commercial activity done in conjunction under ORS 215. So if we didn't have this separate provision specific to psilocybin centers, we didn't have an avenue for approving them. So this was why we felt the need to pass the ordinance in the first place.
It also brought to mind, I guess, maybe from your public comment, you can tell us this, that why the service center would need to be required to be part of the processing and cultivation. Why couldn't it be separate? It sounds like there was a great deal of public comment that said they had to be together. Is it economics? Is it convenience? How would you characterize that?
Right, so and that was something that we, I believe it was Friends who asked us to include a provision that requires it to be in conjunction with the crop itself. It was based on testimony that we received. One in particular that I remember is he brought in a bin, a clear plastic bin, and said, this is the amount of psilocybin that I will be allowed to produce under the OHA rules. There is no profit in this if there is no service center. And so that was sort of the why.
Couldn't they locate in conjunction the service center in a non-EFU zone? Is there some?
We do have it in other zones. We have it in
the resource industrial and neighborhood commercial, if I remember correctly.
Recreation.
Yeah, recreation commercial. Yeah.
And
So we do have a couple of exception areas, but we don't have that many zones that are exception areas, of course.
Yeah.
But couldn't the cultivator and processor locate their service center in where it's permitted? In a zone that is permitted? I guess, I understand that there's not an efficiency to that, but it would also solve the issue at hand.
I guess I don't know your question. I don't understand your question.
So could I put, I could, if I wanted to produce psilocybin and run a service center, couldn't I have the production, processing, cultivation facility on EFU land, and then also in town in a different zone, have my service center in a different location?
Well, the measure states that you can have a service center in conjunction with growing of the psilocybin. So I don't know how you can avoid that.
I think you can. I think it would just be a more expense to the grower. You'd have to go find someplace to either buy or lease, and that would be apparently cost prohibitive.
Which is the model that the marijuana program follows. In a very different way, obviously, but thank you.
Thank you. That's just a sound coming from a computer in the room. There's nothing to be alarmed.
Not comment.
Yeah, Steve, if you want to say something, I'm happy to. Yeah. Any other questions from commissioners? I guess I'll just ask a couple of questions as I look at the staff report and you have it before you, the factors. The factor A is whether the case will require interpretation of a statewide planning goal, rule, statute, goal, or rule. And it seems like it's a pretty low bar to meet that, but I'm curious about your perspective. You don't believe this requires an interpretation of that, or B, whether a ruling in the case will serve to clarify state planning law. I'm curious about your responses to some of the specific criteria that we have before us that we're evaluating as we review the case.
Sure. My take is that there's no requirement for an interpretation on ORS 215 because per 475A, 215 does not apply. So it would be the equivalent of asking if there needs to be an interpretation of a criminal law in order to implement something. It's been excluded from the conversation already. So it would just be reiterating that point if we went to appeal, that this does not fall under the requirements, conditions, statutes laid out under 215 per 475A.
Okay, thank you. And then second two is, so that in that case, then whether a ruling in the case will serve to clarify by state planning law B wouldn't be applicable because of that rationale. I just would like to hear staff, either Hillary or Steve or any staff's response to just the clarity of ORS 475A taking it. I'm interested in your opinion on that response.
Thank you, Vice Chair Lilac. So the relationship between subsection 2 and subsection 3 of 475
A 570 is something that we certainly considered with our Department of Justice counsel. And we came to a different conclusion than Yamhill County has. And we, are recognized here that there is a clear difference of interpretation between the departments of interpretation and the county's interpretation. And I believe, we received a number of requests for guidance and clarification on this statutory interpretation from counties all across the state. And so I don't believe it's clear. And I do believe that an interpretation from the courts on this matter would be beneficial to all of the states. The counties who have opted out, some of them may have done temporarily, waiting for Oregon Health Authority to finish their rulemaking and to see how implementation of the program goes. So again, I do believe this interpretation has broad implications for counties in the state and how these applications are going to be processed going into the future. And, I do think that the situation that we're in now, where we have a county who has an exclusive farm use ordinance that contains uses that are not permitted in Chapter 215 and are not subject to the commission's interpretive authority, is problematic. And I think that undermines, again, the regulatory framework that implements Goal 3. So I as department staff, I do find that to be concerning. I don't know if Mr. Shipsey has anything to add.
My thought is that I have tremendous respect for Mr. Friday and the work he's done for years and years and years and years. And if he arrived at a different position than my colleague who looked at this on behalf of the department, I think that's an ideal thing for Luba to sort out between, smart folks arriving at a different spot. Seems like it's an opportunity to clarify state planning law. So that's why I think it falls well within the first couple provisions of why you would grant an appeal.
Thank you very much. Any last comments by commissioners or questions by commissioners here or online before we proceed to considering the motion, a motion? Hearing none, do I formally close the public hearing and then we'll see if there's, I will do so. Thank you very much to Yamhill County for participating. We really appreciate it and certainly respect your opinions, and we'll move forward from here. So thank you very much. So commissioners, great discussion, clear differences of opinion. I'll turn it over to you to see if you'd like to make a motion or if you'd like to discuss it first.
Vice Chair, I agree with you. I mean, I think there's some pretty low bars here for moving forward with the appeal. Just on the Goal 3 question and the natural resources question. I guess I'm also curious whether or not anybody's talked to Oregon Health Authority about this. So, but go ahead.
Oh, if I may, Commissioner Leslie, yes, we had conversations with Oregon Health Authority and their Department of Justice counsel about our interpretation.
But given that thought, I move that the commission approve the director's appeal of the subject decision from Yamhill County to the Land Use Board of Appeals based on the information included in the staff report and its demonstration that OAR 660-001-023 sub 3 sub A and sub B and sub C and sub D and sub E apply.
Second.
Okay. Please.
Second.
Yeah, good. Okay, thank you. So we have a motion and a second. So let's discuss the motion before we proceed to a vote. Anybody online or in the room for discussion of? I'm not seeing any. I'm just going to make a couple of remarks. One, I do want to commend the county for your public outreach. I think you clearly took this very seriously. You took it on early with the deadlines that we're approaching with the ballot measures and then the implementation date. So you clearly did a lot of work at the local level to do what you thought was best for your county based on what you heard through the public process. That's kind of piece number one. Piece number two, I've heard, I was curious about the department's interest, or not interest, but questions about interpretation from counties across the state. I had heard the same. I know our Deschutes County Community Development Department reached out to counties across the state because there's so much uncertainty. Unfortunately, ballot measures aren't always crystal clear when they're adopted, and that then is fine. We just need to go through the next steps of providing the clarity. And sometimes the clarity may come through the legislature. The clarity can come through local adoption and through the process like we're seeing now, and potentially other matters. So for me, it is a pretty low bar. And I really appreciate the comment about, preserving and respecting the county's autonomy. However, I just find that we're in a situation where this issue does need to be clarified for not just Yamhill County or the other 5 counties that haven't adopted it, potentially any of the other counties that have opted out that may choose at some point to opt in. What might those decisions look like? So for me, I will support the motion. I probably would have just limited it to sub A and sub B, seeking the clarity. But I'll still support the motion. So if there are no further comments from anybody, then and I'm not seeing any here or online. Jan, I would ask that you please call the roll.
Commissioner Lazo,
Aye.
Commissioner Sandoval,
Aye.
Commissioner Jacobson,
Nay.
Commissioner Boyer,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lilac,
Aye.
Chair Halova.
Aye.
So the motion carries 6 in favor and 1 opposed. Thank you very much. And now I believe we might have some comments from Ms. McGrath. Thank you. And I believe Ms. McGrath also provided written comments to us, which we certainly appreciate, but we'd like to provide Ms. McGrath with an opportunity to share some comments with us now that this matter is closed.
Yes, good morning, and apologies that there's a crying child in the background. I anticipated speaking at 9:30, so bear with me. Oh, sweet potato, you're very upset. Okay. Is working to grow a collective of folks that would like to see farmers benefiting from this. What has happened in cannabis with my dear colleague Jason Lampman of State Tree Farms is that it's been a race to the bottom that benefits the wealthy and the money. Now, from folks that I know who are in the facilitation training program, they're talking about the cost of the agricultural product, the medicine, being, quote, negligible, less than 5% of the total cost of these $1,000 sessions. So in order for small family farms, small businesses to compete in any way, they need to have the ability to vertically integrate. They need to have the ability to expand from their existing cannabis farm, have a complementary crop, which really does not have to take up a 5,000 square foot warehouse. I mean, people are growing this in their closets and bathrooms, garages and basements. You can have a very small footprint and grow a large amount. So the ability to grow this product directly on farmland and have a rural retreat center, this is the equivalent of an Airbnb. You know, there's 2 Airbnbs in the same area as my colleague Jason Lampman's farm. People are already doing this. So that's the other reality, is that there is an underground that is not following any of the regulations about waste management, water quality, licensing, and sheds. I know, sweet girl, we're almost done. We're almost done. I know. But I just want to speak to the fact that, you know, this is an issue of justice related to so many of the other goals that you all spoke about on this meeting, from housing to climate change to addiction. On a personal note, I'm a climate refugee who left California after watching a lake dry up. I lived in Northeast Portland at a time when most of my neighbors were Black. They have been mostly displaced now. This same thing is going to happen in this industry if you don't stand up for small family farmers. They're going to be outcompeted by big corporate interests. They're not going to be able to make any money. And what's the alternative? How does that represent justice? This medicine, it is not a drug. It's been used by indigenous communities. I know, by indigenous communities for centuries. You know, people forage it in the forest. So there's a forest, you know, farm use right there. Sorry, I've gotten upset and I'm lost my train of thought because the child. Essentially what I'm saying to you is that if you want to make a social impact where people can have the ability to treat their mental health issues, fight their addiction, manage all these things in a truly accessible way, that starts with small farmers, not luxury retreat centers. So thank you for your time.
Thank you very much. I'm glad you participated and we really appreciate your comments. Thank you. At this time, we will break for lunch and we will reconvene at 12:30 or 12:45. What is our preference? We'll reconvene at 12:45. Thank you.
Now it's, this is like.
Great. Good afternoon, everyone. Welcome back to our Land Conservation and Development Commission meeting today, Thursday, January 26th. We're going to begin our afternoon business meeting section with a roundtable of commissioners sharing 2 to 3 minutes each about important issues in your regions related to the department's work. So I'm happy to either start online or here in the room. Let me just check first. I don't see Commissioner Jacobson or Chair Halava online, but if they would like to begin, they're welcome to begin, or we can be in the room first.
I'd rather you do the in-person first. I'm here though.
Okay. We'll start in the room first. So rather than going down a line, let's just open it up and see if the commissioner would like to begin sharing perspectives from their region.
I'm happy to start us off. So in Southern Oregon, there's some exciting things happening, lots of growth and development. I'll start us off with Phoenix's recent urban growth boundary expansion and the process they're going through there. It's been a long process to get there, but they're bringing in 410 acres of exclusively EFU land, exclusive farm use. A lot of that's going to be developed as industrial employment land, and that was kind of part of the reason for bringing it in, is to bring a kind of more regional employment center. And from what I remember from my time as a city council member was that this area that they recently brought in is considered in Oregon as a very high value because of its proximity to the interstate. And it's relatively flat for the most part, but I think that they're going to find issues with building the necessary infrastructure to support all that, because there are areas of housing coming along with that too. So they're going to have to build a new water tower and all the connecting infrastructure to make that happen. Part of that project, or kind of in unison of that project, is a big project that Jackson County and the city of Medford are working on, which is a really large expansion of a roadway, a really important connecting roadway that runs basically north to south. And it will eventually tie into the new area that Phoenix is expanding into, but it's also an area that Medford has recently expanded into as well, and is currently developing. And some of the plans that are being put forth for development review right now for that area are pretty exciting. It's a nice mix of uses, including affordable housing. So I kind of look at this new urban growth area as like a new node for the Rogue Valley that will have some great opportunities for employment, as well as housing, and provide much needed room for growth. Talent to the south of this project is currently working on updating their urban renewal plan. And they're really, I think, pushing some really cool concepts through their urban renewal plan. A lot of it's really focused around, rebuilding after the Alameda fire. And there's kind of 3 main goals of this plan. And the first one is to recover affordable housing. In the Alameda fire, we lost a lot of affordable housing that was in the type of manufactured homes. And it's been a struggle to regain that style of housing. So they're really hoping to use this urban renewal plan and the tax increment financing to help push this forward and recover some of those homes we've lost. The next kind of objective or outreach, or excuse me, goal is to revitalize commercial areas. So more of a standardized urban renewal approach is, removing blight and helping those areas to rebuild. And the last one is to upgrade city infrastructure. And I would say that's kind of more of a, there's one more. That's also kind of more of a standardized use of urban renewal. And then the last one is increase resiliency to and add and decrease the risk of natural disasters. So we're seeing a lot of work being done around the rebuilding of after the Alameda fire and recovery efforts. And also I think the city of Talon is doing a especially great job of looking into the future and trying to design what they envision as being the future after this fire. The fire was really a horrible event and remains to be a horrible event. It's not like it's over now. I mean, the fire stopped burning, obviously, but the recovery efforts and the mental health trauma that's associated with that is still very present in that area. So it's great to see them taking some initiative to really bring their community back and build it back in a better way. And that's what I have.
Thank you.
I'll go next. It's not so much what's happening in my area, just sitting on this commission, being one of the newer members. I guess I can't say that much anymore. Just how thought-provoking being on this commission is, and it's kind of where my mind is going and educating myself. And with the governor's new goal of 36,000 houses or housing, not houses, but I think I would like that to be a little more clear of all housing. Is, I'm just kind of doing research and talking to some developer friends of mine, and, what kind of incentives could be used to go up. I feel, I keep hearing it's expense, but I think there's more barriers than that, than building up. So I'm just I'm asking a lot of questions and just educating myself, and what kind of incentives could be used. And I know it's probably at the Lending Institute part is where a lot of the holdup is, but that's kind of what I've been working on.
Thank you. Great.
I'll go next. I think one of the most exciting things happening in Eugene actually is I think the city is going to buy the eWeb building to actually locate their city hall, because right now they're temporarily housed in the library. And if they go through with that, I think it's a fantastic location. It's like it's right on the waterfront, and so along the Willamette River, and there's a lot of new development along the river there, and it's also there's a disconnect going from the Willamette River into downtown Eugene, and the Willamette building, the eBay building, basically could serve as a way to connect the new development right into what is happening in downtown. So I really hope that kind of comes through, because it's a perfect example of what we wanted to see in terms of the climate friendly and equitable communities. So I just hope that really does go through. The other pieces in the city of Eugene, I've seen them start to kind of advertise and market the climate friendly and equitable communities rulemaking, especially around parking. And so I just thought that was really good too. I haven't seen that from Springfield, so but
thank you.
Commissioner Lazo, I think for me, it's the same. I'm not sure how directly this pertains to the Portland metropolitan region, but to the entire state. I think all eyes are focused right here on Salem, like the commenter made earlier today. And particularly, I think for folks in the housing world looking to see what direction the legislature is going to go, I think we know where that is. But particularly for our partners on the ground in the jurisdictions, trying to understand, will they have access to the resources they need to really do this work? My sense in most instances, and particularly, again, the opportunities we have in the Portland metropolitan region aren't it's not resistance that we're facing, but lack of resources. And so I think that becomes a really important narrative for all of us in this space to pay attention to. And I think it's very, very real, whether you're, a city of, 600,000 or a city of 60,000. So that's across the board. I just, again, my sense is it's not a lack of willingness, but there's a lot that we're asking of folks in every part of our state right now. And we can't ignore that. But I wouldn't ask any less, frankly. So, but there is a price tag that's going to come with that. So it'll be a little interesting hearing also that we might be in a resource constrained environment, but also with big housing goals right now. So those two things coming together will have an interesting outcome, I think.
Thank you. We can go online before I provide my update. Commissioner Jacobson, Chair Halava.
Sure, I'll start. So kind of talking about the coast region, we are having, at least in Lincoln County, and my understanding is in Tillamook County as well, as we're having more Goal 18 exception conversations. I won't say requests at this point, so I'll call them conversations, but I think as we're seeing sea level rise and older properties and that kind of stuff, getting more people calling into our local planning offices, basically trying to find out what it would do to get a Goal 18 exception. So more of those, like I said, conversations happening. I guess additionally, I just wanted to say, we had briefly mentioned, I think, in the director's report about the governor's executive orders coming out around homelessness and housing. And I just wanted to say that something that the coast is dealing with right now is that we were not included in that executive order. And for most of the coast, we were very upset by this. That we were not included because we do have a large and growing houseless population. And a lot of us feel like this was kind of a systematic injustice because this was based on the point in time counts that you had to show 50% increase from 2017 to 22. Rural communities get less resources to do their point in time counts than larger populations do. So if you have less resources to do your point in time count, it's no surprise that those are low. Also, it did not take into consideration homeless children based on the Kento-Venti Act definition. So it was just adults. We have one of the highest rates in the state for homeless kids in our K-12 schools here in Lincoln County. So like I said, we were really upset that we were not included in this. And so many of our cities, counties, et cetera, across the coast have reached out and asked to be included in that as well as the Coastal Caucus. Our understanding is that there is going to be some type of appeal process that we could possibly use to get included in that, but still trying to kind of understand what that process is and what it takes to kind of prove you want to be. And so at this point, I think we're largely in kind of a reactionary space while still trying to provide the service to our homeless that we need to provide. We really don't have the resources to be doing that. So that's just a couple of coastal updates.
Thank you.
Can I be able to add to
Oh,
that?
please.
Okay, Commissioner Sandoval. Yeah, the Housing Council I sit on, the members had a meeting and they were pretty disappointed that there wasn't going to be more resources to deal with the homeless population in rural communities, especially since that's one of our pillars for our strategic plan is getting more housing resources to rural communities. And so just wanted to back up what Katie was.
I really appreciate that. Thank you. I feel like it's helpful to feel seen. So thank you for that.
Thank you. Chair Halava.
Yeah, and I wanted to second that. I read an article about that issue on just a couple days ago, and I was also surprised, very surprised that it would have turned out that way. So I think anything that we can do to support the coastal communities being included, because I think every time we go to the coast, that's a huge point that's pointed out. And kind of the linkages you made, Commissioner Jacobson, about the resources to do the count, and if you can't do the count, it sort of like reminds me of like census count issues in lower income and communities of color. It's like if the count isn't done right, then it furthers the problem, or if enough resources aren't put toward the count. In the Portland area, I think a big thing is our form of government is going to change in 2025 to have a city manager form. And I think I just read last night that they've appointed the group that is going to delineate the new boundaries for new representatives for that representation in the city. And so, you know, to me, it's like there's a lot of things I talk about that aren't land use related, but to me, everything's related to everything. So the idea of new geographic areas, better representation, more even, you know, equitably distributed, I think is important toward our goals of public participation in the planning process and land use process and in buildings. And my hope is that there's a lot of hopes I have, but one of them has to do with better coordination in the city, speed permitting, specifically when it comes to housing. And so I think some of those inefficiencies, hopefully over time and representation issues will get better. I think we just had a rollout of some funding at the city for affordable housing. So it's nice to see that happen. And then, you know, a lot of conversations in town have to do with workforce, increasing workforce, specifically in my world on construction, because if you don't have the workforce to build the housing, it doesn't help that we have the goals and the money if there's nobody to build it. And we've had a shortage of construction workers 10 years ago. We had a huge shortage. So you can imagine how bad it is now, and especially with a certain generation like retiring, you know, and not necessarily people having come into the field, and thinking about the diversity of that workforce. So a lot of workforce talk. And then not related to our state, but related. I don't know if any of you have been to downtown Vancouver, Washington. If you haven't been there in a while, you might go there and be really shocked in the sense of, in a good way. You know, their whole downtown, I was on the property when the developers were just envisioning, you know, a dense mixed use community, which, you know, walkable, all these things, parks, and they've done it. And if you go there, you'll see a very diverse set of people, you know, all ages, different backgrounds, racial backgrounds. And, you know, for a lot of people, you know, think that, you know, the southern part of the state, of our other state is more suburban. It's great to see how an underutilized piece of property on kind of prime real estate with regard to the river has been reclaimed and kind of restored in the public sense of placemaking. So I thought I would point that out. Thank you.
Can I add on to that, Chair Halava? I also visited that. I've seen a lot about in the news about the downtown Vancouver, waterfront Vancouver area, and finally had a chance to go up there and have dinner, and I was amazed. And, you know, and given the kind of wonkiness of you know, kind of all of us, it really prompted me to try to figure out, and I haven't been able to do it yet, you know, what were the mechanics that put that in place, right? Because I've lived here most of my life, and I was like, that's an amazing transformation. I wonder what the mechanics were, and I don't know that yet, so it's interesting to know. The other thing that I'm surprised the chair didn't bring up for folks who may not have followed the news at the airport, I don't know if you saw the wood lamb roof that went in there. So, you know, another piece of, you know, Oregon economic development that folks are looking at around wood and wood lamb. And so that I think just went up the other day.
Yay. I feel like I talk too much about mass timber, so I hold back on this. I forgot to mention, I have a new position that volunteer position that I've taken on, which is I'm now the chair of the U.S. Green Building Council out of Washington, D.C. And so really kind of what's interesting about the work here versus the work there is that's really thinking about green buildings and all the things that go into buildings. And this work is really about the land use aspects, but both are very centered on climate change and now equity issues. So I'm excited to take on the position.
Congratulations, that's extraordinary. Thank you. I'll provide my update from the eastern half of Oregon. I always like to point that out. I always like to say I represent 18 counties and Steve represents all 36. Yes. I just have to be the broken record and start with housing. Housing shortage, housing supply, affordable housing, housing, and just the significant impacts it has on our economy, on our workforce, on our businesses, on our public services. I think about our essential public services, just in my organization, but I read about this across the state. In fact, I read about it on the coast as well as 911 services, the challenges that they have just filling the most important positions of the call takers and the dispatchers for 911. But it just has such a significant and profound impact on all aspects of life. And I'll just put out a quick kudos to the Bend Chamber of Commerce. They're doing so much to support workforce housing, and not just in the greater Bend area, but far and wide, with great resources that they're doing to champion that. Related is homelessness, houselessness. It's a statewide issue. It's a very significant issue. Certainly related to land use demonstrate. And there's so many factors that contribute to it. So I'll just focus on the issues that relate to us. One is that we continue to see people living temporarily in RVs as their primary dwellings, in the forest, in the desert, in our right-of-ways. We talked about this and we addressed it after the wildfires in the natural hazards in fall of 2020. I think we're going to have a county in our region that may propose extending the temporary use of RVs for dwellings. And I think that's something we should consider how to make that happen, because it's happening. It's happening. It's just that it's happening all over the place without any support. And so what can we do to support it in some ways? Certainly there's continued uncertainty over wildfire mapping, wildfire regulations. We saw the press release that came out a couple of days ago that the map's going to be extended. There's a lot of uncertainty in the legislature, but certainly a commitment to addressing natural hazards and wildfire. And there's just a lot of interest to see where that goes. I previously mentioned water quality in Morrow County, and thanks to Tamara Mabbitt, it's also water quantity. Which remains a very big issue there. And just staying on the water theme, it was the front page of today's bulletin, if I saw that correctly this morning, unless it was yesterday, and my days are blending already. But the drought conditions in Crook County are severe and dire, and water has such a profound impact on land use. Staffing in smaller and rural communities. I've heard Commissioner Jacobson mention this in the past. We've heard it here. Certainly it's an issue now in some local governments, such as the one I work for, but others as well. We talk a lot about how we need to speed up building permitting, and we need to make it faster. Well, I can tell you part of that starts with staffing our offices. I mean, we don't have all the staff we need to actually even process those permits. So we're doing as much as we can. We're asking everybody to do more. And then there are smaller local governments across our state and rural areas where they just don't have the staffing to do anything except process the one permit or a few permits that they have, let alone try to as Commissioner Jacobson mentioned earlier, apply for the grants or reach out for more resources to meet the critical issues that we have. Just the last one is that House Bill 4079. So for those of you that don't recall House Bill 4079, it's the pilot project for urban growth boundary expansions that include a component of affordable housing. Bend and Redmond are moving forward. The commission, prior to my time on the commission, adopted rules many years ago. I think it was 2016, 17, that time frame. They're both moving forward with those projects, and so we'll look forward to those updates in the near future. So thank you very much. Yes.
Transit was a kind of an obstacle for both of those. Transit was a bit of an obstacle for both those projects. That's been resolved, or they've accommodated that?
Yeah, I don't recall transit at this point being a critical issue, but both are. They must be incorporating it somehow. In Bend, it's on the east side. It's going to be very close. It's on the Highway 20 corridor, so there must be a component. I haven't seen the detailed proposal. I've just seen the process. Hayden Homes is working closely with the city of Bend on their master plan and annexation on their plan. On City of Redmond, it's on the near east side as well. So in fact, it's changed names recently, but they both must include some sort of component to that. I think Redmond's is 485 units if they can finally get that moving forward, and Bend is a significant number as well. Yeah, we'll look forward to an update on that at some point going forward. So with that, Director Bateman, if I may turn the rest of the commission business meeting over to you, and we'll go from here. Thank you.
Very good. Thank you, Commissioner Lilac, commissioners, staff, and guests. I have a couple of things to go over as part of commission business, and thank you, Commissioner Lilac, for talking about drought and drawing our attention back to that. I spoke with Office of Emergency Management yesterday, who mentioned they've already received 2 requests for drought declarations in Oregon counties this year. I think it's January still, isn't it? So they have not made their decisions yet as to whether to make those declarations, but they're already starting to arrive. So more to come as the season progresses. Today in our commission business, we have a number of action items, including excitedly some appointments that we'd like to bring to you, some recommendations to fill out our advisory committees and grant advisory committee. We also have a short discussion on evaluation criteria for a director's review that will come later in the year. And then a couple of other pieces on commission roles. We just wanted to revisit with you budget and management, and you've already done your updates. So I think I'd like to start by asking Sadie Carney if she would come forward. She's bringing with her today recommendations from one of our advisory committees on a new appointment for a new seat that has just been created. So Sadie, please.
That is correct. Thank you, Director Bateman. For the record, Sadie Carney, Communications Manager and Policy Analyst with the Department of Land Conservation and Development. And also your staff liaison to the Citizen Involvement Advisory Committee, with whom you will meet tomorrow for your first joint meeting since 2019. Who remembers?
Before
Not
my
me.
time.
Predates me.
So on January 6th, earlier this month, the CIAC, or Citizen Involvement Advisory Committee, held a special meeting to consider applications that we had received for the brand new seat on the CIAC representing Congressional District 6, also brand new. So we conducted the recruitment towards the end of the year using the boundaries that were available online that became effective the 1st of January. Had our special meeting. We considered 3 applications, and of those 3, CIAC members are recommending to the commission Mr. Jimmy Jones for appointment to that seat. Mr. Jones, and some people may be familiar with that name. Thank you for the nod. Is the executive director of the Mid-Willamette Valley Community Action Agency, and he works with homeless and housing unstable populations in Oregon. And he notes in his application materials that in this role, he hopes to elevate the voices of people in poverty, especially the BIPOC population, in land use conversations. He's previous experience with rural populations, has lived in a lot of different parts of the country, as I learned in our conversation, and currently manages a large nonprofit that brings anti-poverty services to over 55,000 Oregonians every year. We, the CIAC members and your staff liaison are very excited for the contributions that he has the potential to bring to our conversations. And in having the opportunity to interact with him prior to this meeting as sort of an onboarding and intro, I'm just very excited to make his acquaintance in general. And I think it's a huge asset to our group. In addition, to Mr. Jones' appointment, both our CIAC chair, Leah Roush, and CIAC member Zechariah Heck have reached the end of their first 4-year term on the CIAC and are seeking reappointment. Reappointment to the CIAC for a second consecutive term is something that we are allowed to do without an open recruitment. And so we just need the commission's nod to go ahead with that. They are both interested in serving a second 4-year term. Quite relieved at that, as Miss Leah Roush is our current chair, and that would be big shoes to fill. And I think both Leah and Mr. Jones will be here in person tomorrow. I believe Zechariah, who lives in Central Oregon, will be attending remotely, but we're looking forward to that conversation. I think there is a public comment that was submitted to the commission on this portion of commission business. Happy to answer any questions about that you might have. or any questions in general. Otherwise, I might recommend a motion.
Thank you. And we did receive the comments, and I certainly appreciate his reaching out and his following the process and expressing his points on that for sure. Do we have any other public signed up to provide comments on this agenda item? We do not. So we can entertain a motion for the appointments to the CIAC.
I'll make a motion. So I move the commission appoint Jimmy Jones to the Citizen Involvement Advisory Committee in the seat representing Oregon's 6th Congressional District, and reappoint Leah Roush and Zachariah Heck to their respective at-large seats.
Second.
Commissioner Warren said seconds. Thank you. Any discussion? Online? Seeing none, Jen, if you will please call the roll.
Commissioner Lazo,
Aye.
Commissioner Sandoval,
Aye.
Commissioner Jacobson,
Aye.
Commissioner Boyer,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lilac,
Aye.
Chair Halova.
Aye.
Thank you very much all. And we'll be congratulating Mr. Jones tomorrow during our joint meeting. So we'll have a full dais and folks here available to join in conversation with you. Thank you, Sadie.
Thank you.
The next piece is just informational, which is to let you know that there's much more of this type of activity to come with regard to our local officials advisory committee. We have several chairs that we'll be trying to fill over the next several months. So not today, but here in future meetings, we'll be bringing some recommendations to you to fill those chairs as well. For our grants advisory committee appointments, we've got Gordon Howard in the room, who is also bringing a number of recommendations to you to fill seats so that we can get that program up and running in time for the next biennium. Gordon.
Thank you, Director Bateman. The Grants Advisory Committee meets biannually in the spring of the odd number of years during the legislative session to come up with a recommended program for priority program for our grants technical assistance grant program that the legislature will hopefully fund generously in the next biennium. And so the committee is required to be set up by statute and includes suggested members, and then there's nothing that prevents us from having additional members beyond that. In your staff report on page 3 and 4 is a list of the members of the committees that we are recommending you appoint. What we did is we reached out to the organizations that are named in the statute for suggested members. And then we also looked, there was one existing public public interest group member, and he now is sitting behind me working for the department, Mr. Biddle. So when I talked to Mary Cal McCurdy, she suggested reaching out to other public interest groups around the state to see if they were interested. And we did that, and we got several people interested in joining our grants advisory committee, and they're reflected on this list. And so you'll see the top is not really an appointment for you. That's Commissioner Sandoval, who's will be the commission representative for this committee. And then the other 11 members are listed. And they're a fine group. And we would recommend, there are several of note near the bottom of the list are the newer members. That being at the bottom of the list doesn't mean they're any less than the others, but some of the groups that we reached out to that agreed to help us with this effort, including Home Forward in the Portland area, Central Oregon Land Watch from Central Oregon area, Representative Chantal Benso, who is also on the Citizen Involvement Advisory Committee from Northeast Oregon out of Enterprise, and Ethan Brown from the Willamette Partnership in Eugene. And also Mr. Brinkley, who was not previously on the group, the Community Development Director of Medford, agreed to be a member as well. So we would hope that you would pass a motion to appoint these individuals to the Grants Advisory Committee. And then we'll proceed this spring with some meetings for them to go over and make a recommendation on our priorities for grants, the technical assistance grants for the next biennium.
Thank you, Gordon. Well, before sharing my comments, let me open it up to commissioners for comments, questions.
I'd just like to say I'm really happy to see Matt Brinkley involved in that. I think it's a great way to tie Southern Oregon more into what this department's doing. And I think Matt's a great partner.
Thank you. Any other commission comments, questions online, Commissioners, Chair Halava or Commissioner Jacobson?
Nothing for me, thanks.
Great, thank you. I think it's a really impressive list, and I think it's also great to have these people in the same room, getting to know each other and talk to each other and coordinate on such an important topic for the commission and the state. This is really terrific work. Great people. Thank you very much. Do we have any public signed up for public comments? We do not. Nobody has signed up. Thank you very much. So, commissioners, if somebody would like to make a motion.
Barbara Boyer, I move the commission appoint the members of the Grants Advisory Committee as recommended in the staff report.
I'll second.
Thank you, commissioners. Any further discussion on the motion? Online? I'm not hearing any. Jan, please call the roll.
Commissioner Lazo,
Aye.
Commissioner Sandoval,
Aye.
Commissioner Jacobson,
Aye.
Commissioner Boyer,
Aye.
Commissioner Warren,
Aye.
Vice Chair Lilac,
Aye.
Chair Halova.
Aye.
Thank you very much.
Very good. Another strong panel of committee members for furthering the department's work. Thank you for that. Just briefly, we wanted to check in on commissioner assignments that are attached to this staff report. In attachment B is the overarching matrix and is hopefully in the format that Chair Halava had asked us to put it in last time we had this conversation. And then the detail of what each of those assignments entails is in attachment C. But given that we've got, some newer members of the committee and there's a lot going on, we just wanted to make sure that we checked in with you as to your time availability, your continued issues and or interest in each of these issue items and columns, and just do a light check-in as to whether everything still looks good to you in those attachments. Attachment B is probably the easiest way to look at it. So have we assigned you anything to which you'd like to argue?
Commissioners, any comments or questions online, Chair Halava or Commissioner
Yeah,
Jacobson?
I had a question just on any, and this is just a general question for anybody, any newer ones that people have not met on before? What's the process for telling us when those meetings are, getting us signed up for those meetings? I'm thinking mainly about the legislative committee. That's what I'm speaking for myself, but there might be other people.
Right. Thank you for the question, Chair. I think some of these may be more as needed, but I'll just do a scan of the room here and see if there are any strong opinions as to timelines. I don't think we have any set. Certainly, if you'd like for us to meet with you sooner rather than later, we can get something set up and going. But until we have our feet under us and really know what's in the arena and what we're tracking, we haven't convened anything yet.
Okay, but I guess you'll coordinate with the people on the committee to set up times for various ones.
Yes.
Okay.
Yeah. I'll put that on our to-do list to get calendar set up, because we know you're very busy and we want to get those scheduled so you can see them coming.
Thank you.
Thank you. Okay. Any other questions?
And then I guess the strategic plan retreat November. I was just trying to look at that November. Is it that it's due November or that we're working on it in November? I didn't know the November.
That was, I guess we should go ahead and update this again. I was actually in preparation for the one that we did hold in November.
Okay.
So we should take that off of there or at least update what we're aiming for next. Thank you. Oh, yes, right. under
We
the
saw,
time bound, yes.
we saw a draft of that, and then I guess we'll see subsequent.
Yes, the strategic plan itself, I believe we're about to do a bit of survey work and open it for public comment and so then we'll be bringing the pieces back and getting it ready to finalize before, I believe the plan is before the end of the biennium. So coming up quick here.
And I guess I encourage anybody else to ask. I'm looking at my things. Somebody might have a question on there. Does anybody have any questions? I guess.
I think my workload looks inflated because haven't been, that part's over, and the 50th anniversary, beyond what the rest of the commission is doing, I'm not really
Great.
that involved in Goal 5 Cultural Resources Rules Advisory Committee. I'm not sure if or when that's going to launch. So I'm in good shape, just recognizing there's a lot of marks that looks like I'm really busy.
That's why we keep pulling you in for other ancillary duties, Commissioner.
Signing yourself up for more here?
Yeah, no, it's just.
Good. Thank you. Okay, we just wanted to make sure that you were seeing that, checking in and still feeling comfortable in general with how we've structured that.
Great, thank you.
Let's see, I think we've got two more substantive pieces. One is the director evaluation criteria, and then I'll just note Rochelle is on deck then to come up next and talk about the Budget and Management Committee report. So we wanted to get these criteria in front of you and get some guidance and comment, and we'll also be taking public comment on this piece as well. As you'll recall, in previous years, the commission has set up a schedule and has had a rigor around director evaluation. And as I understand it, every other year has been more of a light review, and then on the off years has been more of a 360, where we put out surveys to stakeholders, staff, and a broader community for their input. As this one is scheduled really right at 1 year, we thought maybe we'd make this one the light one. Just get some internal comment and get some culture around this going. So we were able to find the previous evaluations that had been used before, and it's a series of 7 questions in a variety of spaces and venues. How's the director doing in all of these places? And then really rated on a scale from 1 to 6, from outstanding on down, and then an unknown, not much information yet to consider. And so I just wanted to put all of that in front of you, see if those categories still hold, if there's anything about that you wanted to change or add. And I would note that this is really, I think, for this round only, as we talked about earlier this morning, the governor also has a set of expectations around director performance, and we'll be providing a template that, as I understand it, we could probably pick up and use in addition to anything else that you wanted to, add from what you were doing before that might be extra. That there's at least a template that governor wants each director and department to be using, so that there's some standardization in the questions across the board. So that'll be coming later. And for now, we have the questions that you've used before that we can keep or change however you like. So I think we could have some discussion around that. And then there's also an opportunity for public comment here.
Great. Open it up to Commissioner Sandoval.
Yeah, for question 7, it says action plan implementation. Do we have an action plan, or is that something I missed? Or
Well, there are a couple of things here, Commissioner. There will be a work plan that comes out from the strategic plan pieces. And so that's really yet to be developed. But we also then have the policy agenda. And so we do have a calendar laid out of some things that we're committed to and that we're planning on. I'm not sure how you used this question in the past. Maybe others who were here and remember can add their piece to it. I suspect it has more to do with the strategic plan and the attendant work plan, but I don't know for certain.
It's a good question. And maybe one idea is we rather than call it the action plan implementation, it's the policy agenda implementation. We just align it with what the document is, if it's that, or unless there is a separate strategic plan implementation
Right.
time-
Well, and I think it's that there are different levels here. We could also bring it very personal and make it the director's plan. And so it might be something that's, specific to the person that might have to do with professional development or relationship goals or things that are not necessarily the broad agency work plan. So I'm happy to land at whatever level of detail you would like for this one.
I just kind of the same question about number 7, same thing, because I think there's one thing to hold somebody accountable for, some goals were set, are you meeting those goals, versus are these the right goals that we think that you should be held accountable for, right? That's more the strategic piece. And I don't read that in there, and particularly with the naming of action plan implementation. So is there a way to evaluate whether or not the department is heading in the right direction strategically? Not necessarily are we meeting the dates, but are we headed in the right direction strategically? And maybe there's a way to massage that whole question into that combination of those two things. But maybe it's part of 4 too, I guess. I don't know, because it identifies agency priorities and resources.
I'll have to say I was going to set to work wordsmithing this, and I thought, no, I'll just copy and paste what was there before and leave it open for conversation. So I think we really have a lot of latitude for what you want this to look like.
I think it's also important for me that this works for you and that anything that you think you would like feedback on from us is included in that. I'm sure that there's lots of balls in the air that you would love to hear or maybe would love to hear from us on. So I would also suggest anything that you think we should add to it.
Good. And in that sense, in that case, then I do appreciate flipping or making sure we've couched question 7 in more of a strategic direction, because I think it's hard to make time in the day to get there. And yet I think it's really important that we're pointed in the right direction and know where we're headed. And it's easy to get lost in the details. So I'd like to be held accountable on the strategic piece, because that's actually my favorite thing. So
Perfect.
Let's do that.
So
The other
was it-
category.
Was it thought process that you would work on this more and put input and then bring it back? Because I think I don't know if somebody said this because I stepped away for a second, like even reordering these to, I don't know, the strategic stuff first.
We could bring it back for the next meeting in the spring and then actually do the evaluation in the summer, if that sounds like a good process for folks.
Yeah, I would like to see something related to DEI. And it could be a subcategory or something, but I think that would be important to add.
Do you have any sort of wording recommendations with regard to the performance of this position? What role it would play, or what you would like to see as what would define success?
Yeah, so it would be having some sort of strategic vision around DEI. Encouraging the organizational kind of climate and culture around DEI. And seeing if there's ways to actually measure that improvement.
We can go back to our DEI committee and also look at the plan that's in the works right now and see if there's something that we could pull out as a metric or something specific to this position. Yeah. Or the role of this position.
Because if there was a strategic plan metric here, which maybe isn't what number 7 is trying to get to, that is one of your strategic plans, but imagine if it wasn't one, it would get lost, right? It wouldn't end up in this. So I think that maybe what you're saying, Commissioner Sandoval, is like to call that one out separately, because that's something that should just continue on regardless of what the yearly strategic plan might be.
Yeah, that's right.
I would support having it separate too, rather than embedded in any strategic plan.
Having the DEI
Having the
piece
DEI
separate.
or equity sort of indicators separate from other strategic initiatives.
I think it's going to be really interesting and important for us to coordinate with the governor's staff as well, given that we have the initial direction or the expectations effectively, but what are they then thinking? What an evaluation might look like? I know it's not our evaluation, but in the consistency as our governor's just going to release the budget and get the legislative session. I mean, it's the first month, and so maybe there'll be more details coming out on that soon. So those of us that, and perhaps it's Chair Holova and I that serve on the kind of the committee that oversees it, we coordinate with somebody on the governor's staff. There's just so much happening in the world, in the human resources world, with how to evaluate executive directors, having just gone through my first one last fall in my position, and so many opportunities for really strong performance measures, performance evaluations that are, I agree with that the director, the executive director, really contributes to how is it that we're going to collectively measure performance, and that it works to serve everybody extremely well. And I don't know how all those answers in front of me, what this would look like now, but I guess final two comments. I really like having the lighter one during the legislative year, just given how busy in particular you and the department are, and then the more robust one in the other year, in the shorter legislative session year. So that would be a good one. I'm just not a huge fan of putting numbers to performance. I like the outstanding, the exceeds expectations, areas that need improvement, things of that nature. And I get it when we do a staff survey, sometimes maybe that's just the easiest way to capture data, and that can be okay. I'm just not having gone through this with my own board. They're not either. It's just interesting, just putting numbers to performance. That
I think that maybe puts the emphasis in the wrong place, right? You're too busy racking up the numbers rather than building the relationships. So I appreciate that. Would you mind sharing the rubric that you just when you said you just went through a process or had experience with one that might shed some light on this?
Yeah, we can.
The other thing we could do is the template that is coming out for director evaluations will be coming from DAS, Department of Administrative Services, in June for evaluations to be conducted by the end of the calendar year. So you could push this off if you wanted to, but if you also wanted to experiment a little bit and go ahead and conduct a light one this summer, we could.
Or could we, sorry, I was trying to follow along. Or could we just say that the evaluation happens in the fall, so we always know we're not hitting a legislative session? Because I think we had a yearly before, and so it would be nice to just have consistency. Then the light year and the heavy year, it's just one evaluation once a year, and then just make it not be conflicting with legislative world.
Yeah, and that's exactly when we conducted Director Rue's evaluation. His last one was in the fall. It was the timing was really good.
Okay, so would you like to then incorporate the template that comes out should be in June, and that would be plenty of time then to fold that into your thinking? Okay.
I think that sounds great. There's no requirement that we perform it by a certain time. I mean, different positions have different requirements, and I just want to make sure that we're also fulfilling our responsibility as a commission.
Right.
In the state.
I think that's right. The way the executive order is written is the governor would like to see evaluations conducted by the end of the calendar year, but for things that are already in play, you don't have to pivot and do this one this time. So we've got some flexibility.
That's great.
And remind me when your start date was?
It was May 1st.
Okay.
2022.
Yeah. Okay. So I think that works too.
Month 10.
It's a full 3-week overlap.
I was going to say, and I think my 5th commission meeting. So good. Well, thank you. I think that's probably enough to bring back for now, particularly since we're interested in getting additional examples from Deschutes County and from the governor's template. That'll help.
I think one more thing I'd like for us to think about here, and I'm not sure where this fits or even how appropriate it is for a director's review, but thinking something along the lines of like staff relationships, like how are we doing at fostering those and ensuring that staff are happy in their positions here, and which can make them a whole lot more effective and keep them here, which helps us do our jobs too. And I'm not sure where that would lie. I'm thinking maybe under agency leadership, but maybe just a sentence in there when you wordsmith about fostering staff relationships and improving work life balances, something along those lines.
And it related to what you just said, Commissioner Warren, Director, didn't you say that we're going to implement a staff survey as a part of the governor's recommendation?
Yes.
So it'd be good to get that survey prior to the evaluations, that those go together.
I believe the template will also be ready for that in June with a due date by the end of the year. So this first time it might be not great timing, but yes, I think one should inform the other. And I think it's an employee satisfaction survey, so that fits right in. Okay, good. Very good. Thank you. I do believe we need to invite public comment for this item as part of the process that we've committed to, but I don't know that there is any.
Okay.
No, there's no public comment.
Good. Okay.
No
Yeah.
one's
Thank
saying
you.
that.
Thank you for checking and confirming.
Very good. And so with that, we'll bring home this report by asking Rochelle Corbo to join us at the front here and provide a Budget and Management Committee report to the commission.
Good afternoon, commissioners. I'm Rochelle Corbo, the budget officer for the LCD and the interim administrative services division manager. Closer. Yeah. Thank you. It's a pretty straightforward report for this month. We did go over this with the chair and vice chair a couple of days ago. We do have some staffing challenges right now in the financial services, specifically of the administrative service department, as I'm serving in 2 roles as we go into session, and our lead accountant is still very new to this state. So we are exploring some options to get in some help to get us through the legislative session, especially with regards to fiscal impact statements. The 2021-23 financial reviews continue to pretty much be on target. We do see underspending monthly in our projections for in-state travel and attorney general fees, which are 2 of the larger expenditures we have. However, we aren't really including them as a savings or available to commit to other areas at this point in time, because of it's really hard to judge either one of them right now as we're coming out of the COVID lockdowns, and we have some new challenges ahead of us in the attorney general area. So we're holding on to those. The cash flow, it's been reported before that we had an other funds cash flow issue, mostly with the Office for Emergency Management getting behind in their payments for our natural hazards mitigation program. They are catching up. They're still about 5 or 6 months behind. However, they were also going through understaffing, and they seem to be on a better track right now. So that situation has improved greatly. And then on the good news front, our coastal program was successful in getting 2 new sources of funding from National Oceanic and Atmospheric Administration, NOAA. That's why it goes by NOAA, I guess. It's much easier. They got some money, about $450,000 in federal grants through the Build Back Better, or now the Inflation Reduction Act. And then they also got another $2 million through the Investment Infrastructure Jobs Act to help secure some property through the Siletz tribes out. I believe it's the Siletz tribes out on the coast. So that'll be exciting. We did get the limitation for this biennium. However, it's mostly going to be money that's funding that's used in the next biennium. As Director Bateman noted earlier, there's no governor's budget yet. So we're anticipating that any second, hopefully now. The other big news item is that the state is going through a number of enterprise-wide changes over the past year. They have integrated a new financial data platform last June that we're continuing to learn. We just switched over statewide to a new timekeeping system, which has maybe some more challenges than they were anticipating on rollout that we're working through in the financial services and HR departments. And the state is also rolling out a enterprise-wide procurement system. Agencies have been put into 3 waves to go live with that system. DLCD is part of wave 2, which is right now. So we have that on top of session and the Workday timekeeping system. So we're pretty busy, but everything seems to be going along smoothly enough. If there's any questions, I'm happy to take them. Thank you.
Thank you. Commissioner, questions? Commissioner Lazo.
Thanks, Vice Chair. I have a question about the, one of the line items in the budget. You addressed the in-state travel and the AG services, but there's, and also looking at the DLCD budget report from 2022 financials that has the agency budget and then the budget adjustments and then the working budget and then the projected variance. It's the professional services line. So
Yes.
it has a $2 million budget. It added 171,000, so it was a 2.2 million budget.
Mhm.
And then it has a projected variance of a $519,000 surplus.
Correct. So yes, that, thank you for calling that attention, Commissioner Lazo. So our budget that we are actually given our funding through the legislature is kind of on a formula that rolls over biennium to biennium. And within any given biennium, we might be spending more in one area or another area. So we kind of rebalance that through a working budget adjustment. And then as the biennium continues, we start to see that we are having some savings. And we kind of go through a rebalancing, like we're projecting now this general fund savings. So what extra work can we do with it instead of letting it revert back to the legislature? There's not a great system of tracking that. And so I've been tracking it in the professional services category because a lot of it does go out as contracts. And so we're seeing savings, which is mostly actually coming through vacancy savings this biennium. And that has a lot to do with the number of limited duration positions we got at the beginning of the biennium that took a long time to fill. And we have one very long time vacancy going from last September 2021, with our person who was serving kind of as the lead IT person. And we've been working with DAS to upgrade that position to a true CIO position that we're not just now getting approval on. So we had a long-term vacancy savings there. And because of the tight labor market, some of our vacancies that are true turnovers have gone on a little bit longer than we expected. So we had a lot more vacancy savings than we normally would have. And we have been repurposing that money and tracking it through the professional services category, which is why you see that deficit there.
Okay. But it looks like there's also a deficit then for the personal services, which I'm assuming is staffing costs, right? Is salaries?
Correct. I don't think.
So it's a variance of 494,968.
Yeah, that's a positive variance, which
Oh,
would
okay.
offset the negative variance. Right?
Okay, so I had those two backwards. So you're showing a deficit in professional services
And a saving.
and a surplus in
Professional
staffing. Okay,
services,
got it.
correct. Yes, thank you. And it projected ending balance would
Yeah.
probably be a better term. And one thing I did discuss with the subcommittee is revamping this report to start next biennium so that it might be a little bit more clear and useful and succinct and easier to follow. So we're working on that too for you.
Thank you.
Thank you. Are there any other questions? Thanks so much.
We'll get all caught up on those AG fees. Don't worry about that.
Yeah, we never know when the invoices are going to come in late. So.
Yeah, good question. Thank you. I'm sorry, any questions online, Chair Halava or Commissioner Jacobson? I'm not seeing any. Okay,
No questions for me?
No.
Thank
Okay.
you.
great. Thank you very much. Back to you, Director Bateman.
Very good.
Does that
Thank
conclude
you.
our?
I believe it does. I'm just quick checking. I don't think we have any more decisions, votes, or public comment that we need to take as part of this item, and there is none. Okay. I think we're all done. Thank you, Mr. Chair.
So do we want to take a 10-minute break until 2? Is there an item for us before item number?
We are running so far ahead, commissioners, that we're trying to see if we can find John Jennings to come and give his sage grouse report a day early. He happens to be in the building and he was going to give it virtually tomorrow, so. Wait, oh,
Maybe we can take
Matthew might be
If
willing.
we
to
could
do
just take a break maybe until
Yes.
2 o'clock, and then
Let's do
that was a 30-minute item scheduled for tomorrow. That would take us 2 to 2:30. And then we could, or even to 2:45 is fine if that's how long it goes. So let's do that. Let's take a break and we'll reconvene at 2 o'clock to give us a few moments.
How do we get some far ahead tomorrow?
Poor guy. Yeah, don't tempt him because you know people get up out of their chairs. I know. For sure. So.
Yeah. Oh, we didn't do two commissioners. I didn't. I should have. Okay. We're gonna just make this adjustment.
They heard us went to break. Everybody went to break, didn't it?
I can see. Are we ready? Great. Welcome back from the break, everyone. Since we're a bit ahead of schedule, we're going to pull an item from tomorrow's scheduled item, agenda item number 11, sage grouse update to now. And we're pleased and fortunate to have John Jennings with us this afternoon in person. So, John, we look forward to your update, and I'm happy to turn it over to you.
Thank you, Vice Chair Lilac, members of the commission. I'm John Jennings. I'm the Department of Community Services Specialist. I have to confess, I'm not quite ready to do this afternoon, so you may have to bear with me just a little bit, but I'll do the best I can. I really think it's pretty straightforward. Ordinance program for protecting sage grouse is substantially embodied in one of your administrative rules, OAR 660-023-0115, and that rule accomplishes several things. And it's unique in the Goal 5 rule picture. We talk about that a little later, but it does several things. Talks about conflicting uses, a mitigation hierarchy, and establishes what the significant sage grouse habitat actually is. We are obligated, the department, to report to the commission every year, which we usually do, the numbers of new approvals in core sage grouse habitat. I'll take a second to talk. Core habitat is really the best sage grouse habitat. It is mapped and has been mapped by the Oregon Department of Fish and Wildlife and was adopted by LCDC. And so it is actually, that map is actually part of your rule. Core habitat was drawn to identify about 90% of the habitat needed to sustain the species. And it really is intended to include everything a sage grouse needs for its entire life cycle. So it has, wintering areas and lek areas, nesting areas, so on and so forth. And so one of the facets of your sage grouse rules that we report to you, we didn't get a chance to do that last year, so we're kind of doubling up and doing it this year. The good news is there's very little development that goes on out there. These are pretty remote areas. I think that the attachment to the staff report shows kind of width and breadth of the core areas, as well as low density and general areas. So there's really only 4 counties that have approved, reported any approvals, and of those approvals are really, again, pretty de minimis into themselves. I'm going to take just a second and talk about the background. I think it's important, and we're getting a little bit further along from when that rule was adopted. But sage grouse have had a pretty important role in the American West forever. They used to be incredibly numerous. The settlers and Lewis and Clark and others have commented on them. Little bit by little bit over time, that habitat has been whittled away, so they don't have as much, and they're not as prevalent as they had been. In fact, they've been reduced in numbers and habitat so significantly that a number of lawsuits were filed coming up to about 2009 that were directing or attempting to direct the U.S. Fish and Wildlife Service to consider whether or not the sage grouse were a candidate species for listing under the Endangered Species Act. I'm not going to get this entirely right sequentially, but they did. Eventually they did. They being the U.S. Fish and Wildlife Service, they studied it and they found that it was warranted. That they felt that the evidence showed that sage grouse should in fact be listed. They didn't do it because they had more pressing things on their plate. And they didn't have the bandwidth to do all the things they were being asked to do and get into this listing posture here as well. But they committed to revisiting that in 2015. And so that's kind of where we come into the picture with the departments and many of our state partners that said, we don't want a listing. We think that'd be really bad. And our livestock industry was very very concerned about a listing and what it might mean for their ability to use and run on federal lands, grazing lands in the desert. And really people expected that it would have the same consequences as it spotted out. You know, it shut down timber economies on the west. I mean, mills closed everywhere, and people are, anyway, it was a really, really bad deal. But we started from a point where they already expected it was going to be listed. So we set out, and the other 11 states set out. Everybody did a little bit different, kind of did their own spin on things, but to demonstrate that that listing was not necessary. And again, the science told us that there was a variety of threats that could result in habitat fragmentation. Several of those things we can't do a lot about directly or regulatorily. Wildfire is a chief threat. Noxious weed invasion, juniper encroachment. You know, I worked really hard to try to figure out how to regulate those out of existence, and it didn't. I couldn't get there. But we're still working on it. But other things, you know, transmission and urban expansion, rural expansion, mining, renewable energy development, are things we could take a look at. It's not those uses in of themselves; it's their characteristics. You know, the sage grouse are hardwired to avoid tall structures. I don't care what it is; it's just tall. They want to get away from it. And large land-intensive activities that can just remove sagebrush habitat. It doesn't matter if it's a park or a parking lot. You know, if it removes habitat. So we worked really hard and had a really great group of stakeholders. Some folks that wouldn't be considered natural allies really came together and worked hard. And ultimately, at the request of Governor Kitzhaber, LCDC did adopt sage grouse rule. It was done in August 2015 on Burns, Oregon. And that rule became a foundational aspect of Oregon's presentation to the U.S. Fish and Wildlife Service of why the listing was not necessary. And in fact, we believe that cemented the service's decision not to list. You know, it was very, very soon after that. You know, LCDC adopted in August. Fish and Wildlife Commission did their thing a little later in August. Governor's office submitted the plan in September, and the U.S. Fish and Wildlife Service came to the Department of Interior, I believe, Secretary of Interior at the time, Sally Jewell, came out and said we're not going to list. So that was fabulous. So I've probably taken up more time than I needed to, but it was a big deal, and it's still a big deal. And we've lost over 1 million acres. I say we, you know, Western United States, of sage grouse habitat in the last couple of years. I think most of it due to wildfire, but we're not entirely out of the woods, I guess. I mean, someone could always petition again for a listing, and we could be going through this all again. I don't know imminent, but it could happen. So I'm just going to go quick to the chase. I'm going to skip over all. I'm happy to visit about the aspects of the rule. But for the sake of time, I think that I will skip over them for now. Again, I can answer any questions, except that I would say a piece that really kind of brings us to what we're doing today has to do with the development cap. And that is, again, based on science. I believe it was often referred to as a CNIC report, that once a particular sage grouse range is occupied or receives anthropogenic impact of 3%, steadily declines. It doesn't take very much. You get to 3%, you're going to lose that range or that habitat. And so we said, let's not get there. We don't want to do that. And so that's why we're tracking these decisions. That's why we did establish a baseline. The Institute for Natural Resources digitized. So we have a calculus of the amount of disturbance in each of these areas. And we're way below it. Some of these areas are tens of thousands of acres. Some of them are hundreds of thousands of acres. And we're way below our thresholds. But still, we want to be vigilant and intentional. So the last couple of years, Baker County had one decision. And in fact, Holly Kearns, Baker County Planning Director, called me and said, John, that was co-located. It shouldn't count for anything. And I think she's right. So, I mean, co-locating a cell tower because they're tall They do count as a potential disturbance because it was co-located. I believe, and if you agree, I think I'll adjust the report to say that there's 0 disturbed acres estimated for Baker County. Identified that table. Crook County reported a non-farm dwelling. And again, Malheur County had a cell tower, although we don't think it got built. It was approved, but I don't think it was built. In conclusion, there it is. That's what we've got. It's not very much. And that's no surprise. But we want to share that with you, and I appreciate your humoring me and let me kind of fly a little uncharted here a little bit and help to explain to you, because it was a really big deal that we managed to avoid this listing. And this rule was just really a fundamental part and a foundational part of allowing the service to determine that there was adequate regulatory mechanisms to arrest a decline of species. So I'll stop there and be happy to try to answer any questions.
Great. Thanks, John. Commissioner questions?
Yes.
Commissioner Boyer, please.
Barbara Boyer. This seems like a unique role for this department. I guess I've never really paid attention to this. I mean, I view sage grouse, at a different level, conservation districts. So this is unique for this department, at least in this agency. And I just came off the heels of my Oregon Watershed Enhancement Board meeting on Tuesday and Wednesday of this week. And so I'm curious, are you looking at what other agencies are doing in this arena?
So Vice Chair Lilac, Commissioner Boyer, absolutely. We continue to coordinate with ODF&W, among others, as well as the service. And one of the components of the rule, if you to read the introductory provisions, it does a couple things. One, it excuses certain uses, so we're not regulating agricultural use. We don't do that in Oregon. But it also encourages the use of what's called a Candidate Conservation Agreement with Assurances, the CCAA. Many of those programs are implemented or administered by local soil and water conservation districts. So what that is, it's a plan, it's an agreement. So the rancher says, I'm going to do this, and the assurance is, I know you know, but the assurance is that if you abide by that plan, in the event that the species is listed, you get held harmless. So it's a really, it was something that was really promoted, and a lot of people, rightfully so, have really sought to engage in those programs. So I mean, the short answer is yeah, absolutely. We will continue to do that.
Because there's a area of grants through OWEB, which is the Focus Investment Partnership. And we have funded a 6-year project out in it's the what's it called? Baker County Partnership, Baker, I can't remember the name of it. And we're spending $12 million in 6 years out there on to save the sage grouse, especially the habitat, juniper removal, juniper's uptick of water intake is huge, and so it's choking out a lot of the sagebrush. But one thing that we did learn in this, which was really funny, they are doing because the predator is a raven, and so they're doing carcass disposal stations. They're building them. I know, because there's a lot of carcass out there in the rangeland. So it was really fascinating. So I'm going to be watching what that looks like. So the ravens don't come in and there's the predator to the sage grouse. So
again, thank you, Vice Chair Lilac and Commissioner Boyer. And COVIDs, the blackbirds have been a huge discussion, and it found that where they're subsidized, through a feed item can impact how they do or don't impact the sage grouse. So I've probably said enough.
I one last question. Why this area? I'm curious why just this location was chosen, the state.
So Vice Chair Lilac, Commissioner Boyer, I believe that the biologists would say that's where the species are primarily. It used to be, I think all over on the east side of the Cascades. with some of the things that have happened and so on and so forth. I think that's their last stronghold, that, really southeast Oregon, which makes up a pretty big intact portion of the national range. So I think that the biologists would say that that's really kind of what we're down to. That's the last best place.
Okay, thank you.
Thanks, John. Other commissioner questions here or online? Commissioner Lazo.
I have a quick question. John, you asked us about Baker County and the co-located cell tower. I guess my question, and with all due respect to Holly, my question is, if there's any chance that, as you said, that the adding a tall structure would impact the sage grouse, then I think we would leave it. If it's next to another tall structure, I don't know sage grouse well enough to answer my own question.
So thank you, Vice Chair Lilac and Commissioner Lazo. Yeah, as I understood it, it is the presence of, there's one tower now, which has an impact, has a shed of impact around it. With presence of another co-located tower, that really doesn't change that buffered area. So it's there as something different, something new, but the area of impact, the impact shed, does not change.
Thank you. Questions from Chair Halava online or Commissioner Jacobson?
Yeah, I do have a question. It sounds like this was a good partnership and a good avoidance at something that might have been really, challenging for everyone to deal with. And so I was just curious if there is some type of white paper or one pager or a way that how this happened kind of has been gathered together so that it might be an example for future things, long after you're not in this role or other people aren't in their roles, that we have some way of remembering how we got to this.
So Vice Chair Lilac and Commissioner Jacobson, we have some literature. I don't have it at my fingertips. I think the custodian of most of that is Sarah O'Brien with the Lamb Partnership, and she's an absolute rock star. And so I'll reach out to her and see what we can come up with.
Yeah, I don't necessarily need to see it. I just was making sure that somebody had done that. Thank you.
Yeah, very good. Thank you.
Thank you. I have a question before we're done, but I want to make sure that Chair Halava doesn't have a question before and I'm not hearing her ask one.
Do not.
John, my question. Oh, I'm sorry.
I don't.
Okay, thank you. John, my question is, in the table, it has the development approvals, and it's really minimal. But my question is, how much interest is there? Do you have a lot of inquiries, and then as soon as they hear about it, they hear about the regulations or the mitigation impacts, it's like, oh, I'm not going to go down that path. I'm just curious about what the interest may be.
So, Vice Chair Lilac, that's a great question, and I've thought of that too and talked about it. Because there is a shadow effect that you don't see, which is what we wanted to have happen. And so I think what tends to occur and has occurred, we don't rest out here about it, but ODF&W's sage grouse mitigation coordinator, Nigel Seidel, is another rock star, does hear about it. And I think a lot of times when he has walked through with them and folks begin to realize the possible scope of compensatory mitigation, then many times they'll move on, they'll select another site. No, which is what we wanted to do. We're not trying to prohibit or stop development just so much as direct it in areas that wouldn't have the same levels of impact on the species.
Thank you. Anything?
John, I can't believe you made it through the presentation without giving the bumper sticker, which I thought of out of this whole thing was the slogan, "What's good for the bird is good for the herd."
So, the Vice Chair Lilac, Mr. Shipsey has quoted a really fantastic person from Lake County, and as a rancher and chairman of the Oregon Cattlemen Association. John really has been a leader in this realm. And one thing he said too, and he said it to this commission, he said it to others, you can't manage it from one side of the fence. You know, it takes a cooperation between the private landowners and the public landowners. You can't do it from one side of the fence. And so that, anyway, that brings back good memories.
Anything else? John, thank you for coming up and allowing us to move your agenda item up on the schedule. I do see we have an item for, it does call for public comment. I just want to see if anybody has signed up for public comment. We don't see anybody that signed up. We did move this up from tomorrow morning to this afternoon. So I would just suggest if anybody wants to submit comments in writing, we certainly welcome them. And if we need to open it up for public comment tomorrow morning at 9:30, we can do that as well. So we want to make sure that we accommodate anybody that would like to participate in the discussion. So thank you very much, John.
Thank you very much.
Do we want to take a break until 2:45 or? You ready to keep going? You have all the parties here. Okay, for agenda item 8. So at this point, I will recuse myself. Steve Shipsey, you can state if there's anything else I need to state, but I recuse myself. I would have a direct conflict of interest, and so I will not participate. I'll leave the building, and
that suffices.
Perfect. That's all I need to do. Thank you very much.
We get to call you back in when it's over? That's on the phone number right here.
And since Chair Halova is not feeling well, I'll be facilitating this conversation today. And just to make sure that everyone's aware of the different titles and names that are going around, because we've had to switch over. Everyone can refer to me as Commissioner Warren. You don't need to call me Vice Chair or Vice Chair. We can make it really simple. So at this point, I think I'm turning it over to staff. To John.
Good afternoon again. John, for the record, John Jennings, the Community Services Specialist for the Department of Land Conservation and Development based in Bend, Oregon. I apologize, I had to run out and get my other staff report and notes for this item. I'm going to use the staff report in kind of in conjunction with the PowerPoint. I think if that's okay. If I can figure out how to do it. And I get a little closer so you can hear me. I apologize for that. I'll try to do better. So I'm not sure if I'm doing that or. Okay, I think that. There's a place, I think that's the place it will start. And see if I can move it. Okay, there we go. So, as you know, and you've seen the staff report and the attachments and probably some comments, I hope. So the department is requesting approval from LCDC to appeal to the Land Use Board of Appeals, a local Deschutes County decision. The issues here or the features here in this proceeding will be based on the factors for an appeal. They're in your administrative rules. They're listed. I won't read to you. So of course, you've done this before already, so you've probably been through this once already. But we're not debating the merits. We're not retrying the case. We're really going to be looking at the situational aspects in light of how they compare with those factors, which we'll get to here in a second. And like I said, this is not a new land use hearing. It does have to do with land protected under Goal 3 and whether it should remain protected under Goal 3 is your agricultural goal. So a quick case overview, and again, there's a description in the written staff report. Well, it's about 710 acres in this tract. It's probably be characterized in ecosystem, probably be a sage steppe, juniper woodland type situation. It's mostly flat and it really resembles a lot of the lands in central and eastern Oregon. They bear these characteristics. I'm going to just take for a second. I want to be sure I commend Deschutes County staff on their work on this project. This was a big project to manage, both based on the amount of information, but also the amount of public participation. They just did a really fine job. They deserve some commendation there. So I guess back to our point here. I think I may have done something with their PowerPoint, but So decision is this: decision amends their local comprehensive plan and rezones the property from exclusive farm use to rural residential. And so the basis there is that in their estimation, the estimation of the county based on the applicant's presentation is that the property does not qualify as agricultural land. Again, that's based on one of the commission's rules, which is cited there. Now, not qualifying for agricultural land means it's not protected or does not deserve protection under statewide planning goal 3. And then therefore it could be available for something else. And in this case, that something else that's being asked for is rural residential. Our position, the position of the department, as well as some of our sister agencies that joined us in comment, Department of Agriculture and Farm, Fish and Wildlife, is that the property does deserve protection under goal 3. And we do believe that it meets the definition of agricultural land. So I'm going to go ahead and move through that. I'm not going to read this to you, obviously, but it's kind of these next couple slides provide a little bit of backdrop. This definition is included in total. I think it's footnote 2 on page 2 of the staff report. The takeaway here, or what I'd like to convey, is that there is a clear and objective measure of whether property qualifies as agricultural land. That's based on soil type, and the soil, generally the controlling soil type source is the Natural Resource Conservation Service, soil inventory and studies. So lands that are predominantly class 1 through 6 in Eastern Oregon, 1 through 6 are agricultural land. That's it. It's clear and objective. Of course, as you're familiar with the soil categories, 1's the very best, and 8 is the very worst. So those 1 through 6 soils have been determined from policy basis to have value as agricultural lands in and themselves, on their face, without any other question. Lands that fall outside of that may be predominantly class 7 or 8 or combination thereof, would have to address these other factors. They're candidates for a determination that they don't deserve protection under goal 3, but they don't go all the way just by not meeting those soil classifications. So that puts us in B, C, and D. We're looking at item B, that suitability for farm use and how it's defined in the statute is really the centerpiece of our concern and our argument. The applicant in this case did submit a alternative soil study that demonstrated sufficiently that it is predominantly class 7 soil. So again, that gets them in the door. They're a candidate for a different determination, but they have to go through these other things and satisfactorily demonstrate them. Real quickly, definition of farm use. This is a skeletal definition, but just kind of wanted to get on the page and identify how these definitions sort of come together and should work together to help inform a decision. So as I said, this is pretty limited. It just kind of just scratches the surface. The full definition, I think, is in footnote 3, which is the bottom of page 2 and 3. I don't do this very often. I'm just going to read this real quickly. This says, and this is quoting the statute, as used in this section, farm use means the current employment of land for the primary purpose of obtaining profit and money by raising, harvesting, and selling crops, or the feeding, breeding, management, and sale of, or the produce of livestock, poultry, fur-bearing animals, or honeybees, and for dairying and the sale of dairy products, or any other agricultural or horticultural use, or animal husbandry, or any combination thereof. Pretty broad. That's extremely broad. And it goes on to talk about things like Christmas trees and horses and species that ODF&W manages, so as to be chukar, quail, or ungulates like elk or deer, I suppose. Anyway, the point there is the definition of farm use is pivotal in determining suitability for farm use, and that definition is incredibly broad. gonna go here. Here's where we're at, our appeal factors. Again, I'm not gonna read them to you, and we've provided them to you with our assessment in the staff report. I'm gonna look at my notes real quick, see what I'm missing. So looking at the first two, we believe absolutely that this case satisfies those two appeal factors. And again, I'm sorry, it's not a majority. It's not have to have all of them. It's one. The commission needs to find that one or more of these appeal factors are satisfied. We believe absolutely that the first two are satisfied. This case absolutely requires interpretation of statewide planning goal, statute, or rule. I mean, we're looking at goal 3, you cited statute, the U.S. administrative rule. It absolutely, in our mind, satisfies that. And B, also, whether a ruling in this case will serve to clarify state planning law. We absolutely believe that that's satisfied. And we believe that the items that are issued in this case will help us, as well as others, counties and property owners and applicants, have a better sense of how this rule works, how this definition is applied to determine when property is or when it's not deserving of protection under as agricultural land. Going through the rest quickly, no, we don't think we need to enforce anything right now. The significant under D, significant resources, we're not aware that there's any significant resources inventoried for that site. I want to stress that inventory, which means included in an inventory in the local comprehensive plan. We do think, though, that as an overall objective of our strategic plan, we think that prematurely or unnecessarily retiring farmland does help advance the objectives of our program. We want to avoid prematurely or unnecessarily retiring farmland. Item F here, the better way to accomplish the objective. We haven't identified one. I guess I'm going to take just a second here, and I'll resist kind of responding or thinking about some of the comments that we may hear and hope we do hear. There have been, if you saw the applicant's comments, there was some mention of us pivoting to recommending a clustered kind of a cluster development or something in the resident subdivision. That surprised me, and it surprised me because we didn't offer that because we never thought anything. We never agreed to that. That was not something that we'd ever really considered, and we didn't consider it because our primary objective is seeing that this property and properties like it are retained for agricultural use and available for agricultural practitioners. So I think that's my piece or proposed motion. Again, I think this is included in the staff report. I think it's be surprised, but we would propose that the commission utilize this motion or one like it. And with that, I'm going to see if there's any questions. I know our friend County Commissioner Tony Bone from Deschutes County is here, and I believe the applicant representative is either here or perhaps on the video. And would obviously welcome their thoughts and comments. But before we go there, I'd try to answer any questions if you have them.
Thank you very much, John. Open up to questions to our commissioners online. Anything from you two?
I guess my question is, this seems like a topic that may have come up before, and I was curious how that does or doesn't, this type of case, let's say, does or doesn't influence this one.
So, Commissioner Warren and Chair Halova, we have talked about the conversion of agricultural land to a non-resource status in terms of a kind of a policy setting. There was some contemplation at one point of adding it to a rulemaking. Now, unfortunately, that got overshadowed like so many things did with the workload that the legislature has assigned. So that's my familiarity. I also recall, maybe some of you do too, that we did have an intern that put together relatively thorough study on what non-resource lands could be and how the process worked. I haven't been a participant in an appeal or proposed appeal of a non-resource case at the local level. I don't know the department hasn't, but I know that I have not been.
I don't know if it's appropriate for Steve Shipsey to respond to that or not. I'm not quite sure.
Virtual chair. Yeah, this is Steve. And, there are cases that will provide some insight to how Luba might approach this, but there wasn't one that we found that was directly on point. So in terms of the first two factors still being satisfied and that a ruling on this particular circumstance would clarify state planning law, still felt that to be the case.
Thank you.
Commissioner Jacobson, any questions from you?
None from me, thank you.
Okay. Commissioners, anything from you?
Thanks, Commissioner Warren. And my question was sort of similar to Chair Holova's in that I guess in reading through the materials, it seems like the case turns on sort of the underlying facts of the piece of land, rather than the interpretation of the rule. But Steve or Mr. Shipsey, what you're saying is it sounds like this hasn't been sort of adjudicated before, kind of the way these things are interpreted. It seems odd that it wouldn't have been, I guess, and particularly on the two instances here, right? The soil composition and I guess the profitability piece, right? Whether or not what constitutes farming, what constitutes agricultural land, and what constitutes farm use. So those are two questions at hand.
Yeah, we've seen the case more broadly where the profitability of farmland in conjunction with other uses in the surrounding area. And this seemed to be presenting the looking solely at these 710 acres, the 9 tracts that comprise these 710 acres in isolation of that agricultural operation in the area, whether it was still met the definition of farmland kind of in isolation.
Okay.
Any other questions? Okay.
Yeah.
So
Yeah.
Go ahead.
I was trying to think about if my thing was a question or a comment. Yeah, I'll hold it.
Okay.
So thank you. I'll go ahead and step down and allow our guests to step up for their 10 minutes apiece. Thank you very much.
Great. Commissioner DeBonne, whenever you're ready. And welcome. It's nice to see you again.
Commissioner Warren, Chair Holova, and Commission and Director Bateman, thank you very much for having me today. When I stepped into this room, I remember that I was here about 10, 11 years ago for the comprehensive plan acknowledgement for the city of La Pine, which is our youngest city in the state of Oregon. So we were standing right here on the floor taking photos, acknowledging that first comprehensive plan for a young city. I am here to advocate for the LCD not to participate in the appeal of this county land use decision. The applicant requested a comprehensive plan amendment and zone change from resource land to rural residential exception area for 710 acres, multiple parcels at the north part of Deschutes County. I would say that this land is west of Redmond in the proximity of Lower Bridge. When you live in the area, you're like, oh, it's out by Lower Bridge, west of Redmond. Lower Bridge is the area where farming for a profit is done in Deschutes County. The elevation is lower than Bend, and La Pine even goes up higher from there in elevation, and the soils are better. With flat ground and irrigation water, if you have flat ground and irrigation water, profit and money can be created. On another note, in 2013 and again in 2018, the Oregon Department of State Lands, DSL, applied for a comprehensive plan amendment and zone change for 380 acres and then 260 acres respectively. The parcels are on the east perimeter of the city of Bend. The application or the justification for this application was soil conditions, lack of irrigation water, and no history of farming. So this is the east side of Bend opposed to the north edge of our county. Now for the 710 Eden Crossing properties, 710 acres, they are located on rocky outcropping above the lower bridge farming parcels. They may have been some historical grazing, but the applicant has shown in the record that there is no opportunity for profit in money. The soil analysis was provided by a soil scientist acknowledged by DLCD, and there's no agricultural water associated with this property. There's no water rights even to be had. A hearings officer decision was published that recommended approval. This matter went before the Board of Commissioners and it was approved by following the fact pattern from the hearings officer as presented by these previous applications. One of these items was discussed and mentioned as a reason to deny this was water. 710 acres could be divided into 71 10-acre parcels, rural residential lots that would qualify for an exempt domestic well. As commissioners, we are not in the domain of making decisions based on waters. This is not a decision point during this process. Oregon Water Resources Department provides direction on this, and part of the decision process included, is water available? So yes or no. Would they be authorized to drill a domestic well? The answer is yes. In the record of county application is a letter from DLCD, ODF&W, and ODA. The letter reads like a story about how someone might use their land, and there's interesting statements, but no content to hang someone's hat on to support a denial. And that was in our record. There's even a statement that mentions Oregon Water Resources Department and Deschutes County processes ensure that new water use is mitigated. I'm experienced in making some of these decisions. Either you have irrigation rights if you're going to use it for farming, or you're allowed to put in a domestic well because we have no water limiting areas that the Oregon Water Resources would say, yeah, that's an area of concern. Let's not allow new wells there. We don't have that. We take water seriously in the basin, and when it comes to land use, and it's not a mechanism to deny. Does the state land use system make land use rules to control speculative land purchases? Because that came up during our hearing. They bought it, now they want to do something else with it. If the intention is to have rural open space, this is another topic. If the intention is to have open rural space, then maybe there's a different zoning called open space with a lower tax burden. Thanks for letting me speak. I'll be available for questions. I do ask you to not support this appeal. It's a well-reasoned decision by the final local decision authority. Thank you very much for having me today.
Thank you, Commissioner. Online commissioners, anything you'd like to ask?
No, thank you.
Yeah. So open space with lower tax bracket. Can you speak a little bit more about that?
Well, as I say, we live in a place where it's nice to know that land over there is open and the deer are eating grass on that land over there. We're referring to somewhere else. This is privately owned land that we're talking about. Private property owner, zoned EFU should have the opportunity to farm for a profit. This is a rocky outcropping above a beautiful green. If you look at the map, the overhead map, beautiful green profitable field. And then you go up to this elevation and it's a rocky outcropping, no history of farming for a profit. So if the intention of the state land use system is to say, well, we want that private property to be, low density, no development, maybe one house per 180 acres or whatever, some scenario, maybe that's a change in our land use system. So that's a big one. That's a, big home run type thing we're talking about here, but it's private property. And if the intention is to leave that person's private property that they pay taxes on open space, it puts us in this spot.
Barbara Boyer, thank you for your comments today. I have a couple of questions. It's EF what now zoned?
So exclusive farm use, just EFU is how we refer to it as. We have some subzones in Deschutes County, EFUTB for Terrebonne or whatever, but it's just zoned exclusive farm use.
Right, but so my farm, I'm a farmer, so I'm EF 80, so I'm 80, 80 acres. Do you know what this is?
The sizing, yeah, it may be 80 acre minimum. So
Okay.
I think of it as RR 10, MUA 10, and then, yeah, farmland. So yeah, maybe the small subdivision would be 80 acres. So it's probably just different terminology, but I see what you're saying.
Okay.
Yeah. So it is. It's just, we don't
EF
refer to
80?
it as 80, but yeah.
Okay, that's how I
Yep. not a
talk about
problem.
mine. So let's see, what are the surrounding lands now?
Well, so surrounding lands, as I say, you can pull up an aerial view of this, and there's pivots at Lower Bridge. So as I say, if you think Lower Bridge is the road goes across, and there's pivots, and they're beautiful green pivots. They have agricultural water, referring to irrigation water. There's an irrigation season, you turn it on. Those irrigation pivots, and I'm going to just speak offhand here now, have, some value of soil, and it's very different. This is the high elevation Eastern Oregon soil condition. So as I say, and I'm sure John can get more clear on this, because this is what we do all the time when we're having testimony in front of us. It's like class 5, 6, 7 soils, and it moves up a class when you have water on it during the growing season. So that kind of situation. So, but it isn't like there's this outcropping is a grazing area next to another grazing area where you could work them both together. They're kind of disconnected operations, either a round pivot that has water or a rocky outcropping next to it. If that helps.
Yes. And I don't know if these are questions for you or John, so I don't know if I'm unsure, but I'm gonna keep firing away. So, with my questions. Has there been a farm impact study done?
So
we
as I
know?
say, terminology maybe, because part of the record is the fact that they showed that they could put like 3 or 6, depending, you could put 6 cows out there for like 3 or 4 or 5, 6 months, and 3 cows for a year or whatever. So yeah, I think that was in the record of our
So this is the surrounding areas, about the impacts of a development with the
Okay.
surrounding agricultural. Okay,
terminology.
thank you.
But it's different uses, as in this rocky outcropping, it's not even, it doesn't have a lot of AMUs, animal month units or UMs. And a field is grown to cut and bale and remove to deliver. So they would be kind of separate uses if it was grazing on this property and cut and bale on the other property.
Well, and to me, farming is not just soils. There's other parts of farming. Rangeland is important for grazing. So that's why I was asking some of those questions. And then I know you can dig, you say the wells could be dug in this area. Okay,
Yeah. I mean,
Okay.
there's some depth to groundwater, yeah.
okay.
They may be expensive. That's why I'm,
Mhm, right.
yeah.
Let's see, do I have anything else? Not at the time. Thank you.
Thank you so much.
Thank you very much.
Thanks for having me today.
Appreciate it.
Great day.
And passing it off to Kenneth. Kenneth, you have 10 minutes. Thank you for coming.
Good afternoon, commissioners. My name is Kenneth Katzeroff. I'm an attorney here at Schwab Williamson and Wyatt. I don't know why my camera makes me look like I'm in witness protection, but maybe I should be. Not quite sure. I apologize for not being there today in person. I'm preparing for another contentious hearing. I'm going to try to answer one of the questions that was just asked around what was kind of the surrounding land uses. And this property is actually, I don't want to use the word unique, but it is unique. It is on a very steep elevated plateau, and there is some irrigated agriculture to the northwest, but that is quite some distance off and an elevation change of something like 300 feet on pretty sheer cliff walls. The rest of the property is either rimmed with BLM land, which is not used for grazing, it's used for recreation. And then there is other rural subdivisions that are rural residential zoned or MUA 10 zone, which are rural residential exception areas in Deschutes County. And then on kind of the southeastern side, there are other properties that are in fact zoned EFU also, but almost every single one of them have received a non-farm dwelling approval. And so they've actually been taken out of agricultural because the soils are so bad here. In this case, we have a property that the soils analysis was done on and acknowledged by DLCD of having about 71% class 7 and 8 soils. What we've learned since then, actually, when we went to go look at doing some test pits to establish septic potentially in a future subdivision, is that the area that we thought was class 6 is actually not. There's less than what was originally identified. The reason being the soil depth is much less. And so if we go to an appeal, which whether or not this commission authorizes DLCD to continue with theirs, we will still have an appeal by Central Oregon Land Watch. And I think that's important because it's not like nobody's going to be litigating these issues. It's whether or not this agency should be spending resources on doing it themselves also. So my point on that is, if we come back on a remand to answer some of these questions, we actually have additional evidence that supports our position that this is not a piece of property that should be in agricultural land. So I want to talk really quickly about this issue of farm use. And as far as we understand it, the agency took a little bit of issue on this idea of primary purpose of profit. And that, in our opinion, is something that is kind of black letter law. The Weatherall case, Weatherall versus Douglas County, which the Supreme Court decided in 2007, and which DLCD participated in, although not a named party, they filed briefs in it, pretty clearly tells you what you can do, and pretty clearly tells you that profitability is one of the main factors, and that indeed it is the land itself, the particular property, that has to be able to support the agricultural use. And that's important because it's different when you start to get into some issues about having a farm tract, which is not something that is at issue in this case. You do look at how you can put it into conjunction with other properties. That's a completely different issue than what we have today. And that's important when we're talking about this particular case. But profitability matters, and the land itself matters. So what we did is, there's not really a dispute, I don't think, at least with the agency, as to whether or not you could do irrigated agriculture here. You can't. So the question comes down to whether or not you can make a profit in grazing, or whether you could even support maintaining the property in grazing. And simply put, you cannot. The agency submitted its own evidence, and when I say evidence, they looked at it and said, we think, based upon NRCS data, you could support a maximum of this many cows, this many AUMs. And when you actually calculate that out, it shows that in a wet year, in a good year, the most amount of money you could make grazing. This doesn't take out expenses at all, but the most amount of money that you could make is less than $10,000. On 710 acres. That's the evidence the agency put in, okay? In a dry year, which Deschutes County has been in drought for a long time, it's less than $5,000. Those numbers are very low. So what did we do? We had 7 professional ranchers come to this property, tour the property, and tell us and submit into the record whether or not they would add this property to their stock, whether they would want to purchase it, whether they would want to range it themselves, whether they would add it to their operations in surrounding areas. And those 7 ranchers graze something like 45 or 50,000 acres in Central and Eastern Oregon. And every single one of them said, I would not. It's too rocky. It's too remote. The startup costs we would never do it. There's no productivity. And so what we look at is we have a record that, quite frankly, is stacked with evidence that says you cannot make a profit here. You would lose the property if you tried to do so because you wouldn't be able to pay your taxes. So I really appreciated what Commissioner DeBonne said about rural open space, because that's something that was kind of brought up a little bit below, is, well, people just don't want development on this piece of property because it seems like it's a big piece of property. 710 acres is big. But what we're looking at is 710 acres that you can't even make $10,000 on before expenses, and putting a rural residential designation on it that would allow 1 lot for 10 acres, and that's it. And if you want to protect it as rural open space, then I told the Ms. Donald with the DOJ this, we would be supportive of looking at a legislative effort or new rule or new statewide planning goal around having a rural open space designation. But right now, this property has been taken out of farm deferral by Deschutes County because it doesn't qualify. There is zero history of an agricultural use ever. And we submitted evidence in response to comments by Landwatch and others on any number of potential agricultural uses, from raising bees and having primary source bee farmers say, yep, couldn't do it, to raising lavender, to game birds, to any particular thing you can think of, and got expert opinion saying you couldn't do it here. You just couldn't, and that they wouldn't add it to their own existing holdings. So all I want to say is we think that this appeal is kind of a waste of resources that the agency could be spending on other things, and that we don't think that the case law is that needing of additional analysis or additional clarification. It's pretty clear. I guess the last thing I would say is to respond to Mr. Jennings. It came up in my communications with Ms. Donald on a phone call about, well, if you did a development, could you do it as a cluster? And so that's why we included that in our letter. That also came up during deliberations and other processes before the county. And the reason I think that's relevant and why that kind of ties to the rural open space issue is Deschutes County's cluster and plan unit development ordinance, as well as the LCD's own, talks about doing 2-acre lots and preserving 80% open space. And so can there be some tandem there in a subdivision and some negotiation? Yes, but that requires the agency to actually communicate with applicants, talk about applications, and look at a path forward, as opposed to coming to a hearing for the first time and kind of blindsiding applicants. So I'll leave it with that. I'm happy to answer any questions you have, but we don't think that this case is really that. There's not a lot to interpret here. It's already been done, and it's been done recently by the Supreme Court. Thank you very much.
Thank you very much. Commissioners online, any questions?
No.
None for me, thank you.
Okay, commissioners in the room?
So, yeah, I'm not going to talk about the farming issue. Just to me, this seems like a definition type, a definition issue is kind of where I'm leaning on this one. So thank you.
Okay. Thank you, Mr. Katsaroff. Appreciate your time.
Thank you.
And we're going to turn it back over to staff to be part of the LCDC deliberations.
So thank you, Commissioner Warren. I feel like this position is laid out pretty well. I can try to respond to some things if you would like. I will say the question to Commissioner DeBonne about the farm impact test. I would say that there was not, I don't believe there was one done in the way that one might have been done for a non-farm dwelling, not because they didn't want to or because they avoided it, but because I don't believe that is a requirement as a matter of law. So if it didn't happen, it was because that they weren't required to do it. And I would just say, I just say that I agree. I pretty much agree with the description of the property. I would I would again say profitability, of course profitability counts. If we didn't mention it in our comments, I think we believe it was self-evident. So we would not be arguing that profitability doesn't count. We're really not arguing, I don't think, or positioning ourselves to argue the definition of farm use. It's how that term and the definition of statute is used in conjunction with the definition of your rules to make an informed decision about whether property deserves to be protected for agricultural use and agricultural land. And profitability means different things to different people. And things acquired at an agricultural value can change the dynamic. So if you acquire an asset for what it's worth for agriculture, a certain dollar figure may sound acceptable. Whereas you purchase that asset for residential speculative real, recreational value, which can't be competed with by agricultural practitioners, that same dollar figure may not sound like very much. So again, I'm going to resist the urge to go into the merits and prop up some of our arguments. But I would say, I guess I feel incumbent to say, because I don't want to leave the commission with the wrong impression. There were some comments made, and I appreciate, I get it, about blindsiding the applicant, offering comments at the last minute. Of course, our preference would be to provide comments weeks ahead of a hearing. Sometimes it just isn't able to happen, and I'm not going to make excuses. I'm saying, life happens sometimes. But deadlines are deadlines for a reason. They distinguish between what gets in on time and what doesn't get in on time. We made the deadline. We got in on time. The fundamental question is, were things provided on time? And we were. So we met that obligation. Again, I just don't want the commission to come away with the presumption or assumption that we wait till the last second to drop a bunch of stuff. We just don't do that. Sometimes, unfortunately, circumstances happen. But I'm going to stop there. I could go on, but I won't. I'm going to stop there and ask if there's any questions. Before I do, I guess I would say, open space was mentioned. There is an open space property tax deferral. I don't know how used it is or well used it is, but I believe it's available. I think it's similar to the farm tax deferral program in ORS Chapter 215. Just something perhaps to think about. I'm going to stop there. Again, it's the department's recommendation, and we believe this is an important case. We believe getting rulings on these items would be very beneficial to improving the collective understanding of what it means to demonstrate the property is not to be considered not available to be protected, as undeserving of protection under Goal 3. Again, we think that list of farm use is awfully broad. So I'll stop there. You have a recommended motion. We have to try to answer any questions. Thank you.
Commissioners, any clarifying questions for Mr. Jennings?
I have a comment. I don't know if it bleeds into a question or not, so I've been trying to figure out what to say. I mean, I focused on there was 2-3 sentences in the staff report, and I just wanted to read it, and then maybe I'll formulate a question by reading it. So it was saying, first, the definition of farm use is very broad and includes numerous activities that are not dependent on irrigation, water, or even productive soil qualities. Second, and more specifically, the subject property is characteristic in soils, terrain, hydrology, and size to many central and eastern Oregon properties that have been historically or are currently used for livestock grazing and operations, utilizing several non-contiguous properties to meet needs of livestock over the course of a typical year is an accepted farming practice across much of Oregon. It seemed like those 3 points weren't considered, I guess, in the last testimony in support of doing this. And I think it feels like that's where it bleeds into, well, there's a lot of other lands that are conducting farm practices on similar soils and properties. And so it feels like, and maybe that's what Commissioner Boyer was talking about, definitions. It seems like farm use is a potential, and whether the potential is realized in this year of 2023 or not is different. Like in some year, suddenly the potential becomes available. It's like housing in some ways. It's like the land zone for housing. Housing doesn't happen because of a multitude of factors. One year, those factors come together and suddenly housing appears on the site. So that I'm trying to relate it to things I understand better. Doesn't mean that so I don't know if you could respond to that in the sense of that seems to be the center of the staff report's argument is around this is similar to other lands that are being used, and it just so happens that this one isn't, and that the contiguous nature, which I believe the other folks brought out in testimony in the sense of this land over here is not contiguous because it got changed its designation. This land over here is not contiguous. It got its changed designation, that if you change this designation, it will participate in that kind of snowball effect. So I don't know if that's what we're saying here, or I just want to get your feelings on that.
So, Commissioner Warren, thank you, Chair Halova. Those are unsurprisingly very astute observations. And I appreciate bringing that up. And you know, I've tried not to dive into the merits too deeply, but you're right. It's in the staff report. So let's talk about it. You know, as we have stated here, and I mentioned too, farm use is broad. It's not dependent on irrigation water. Obviously, irrigated farming is dependent on irrigation water, but it's all other categories of farming. But maybe more directly and more specifically is that our observations and our understanding of how ranching works out there, which is based on a lot of things, including coordination with Bureau of Land Management and Oregon Cattlemen Association, is that this is what grazing land in Central and Eastern Oregon often looks like. It often looks like it. And ranching operations are often very dependent on land that closely resembles this property. And so you're right. We believe that someone could use it. Now, it may not be the property owner, but I'm going to go off script a little bit here and relate a conversation I had with one of my person I really looked up to, a guy named Hanley Jenkins. Some of you know Hanley. And I remember asking him about the statutory requirements for minimum parcel sizes on rangeland, which was 160 acres. And I said, Hanley, that's not big enough for a ranch. And he said, no, John, it's not big enough for a ranch, but it's big enough to ranch. It's big enough for someone to be able to use, and someone will use it. And so I think that's part of that's a big part of the you know, really maybe the epicenter is that this property is, and there's evidence in the record, we believe we placed it there adequately. This is, and in fact, applicant placed there. This is pretty decent rangeland. I mean, capable of supporting, you know, 1 AUM per 5 or 10 acres is pretty good. There's a lot of ranches that don't have, you know, do more with less. And keeping it intact, we believe, which it should, because we believe it deserves protection under Goal 3, retains its availability to be used. And if it is unnecessarily converted, and other lands like it are unnecessarily converted using, you know, some sort of fact pattern here, then their availability goes away too. And one thing I know for sure is that can't be reeled back in. So we believe that this property and properties like it qualify as agricultural lands. We believe they deserve to be protected. The utilization of non-contiguous properties, every ranch I'm aware of uses a combination of deeded and leased land. Everyone. I know of a rancher in Powell Butte that runs cattle in Burns. Hauls his cattle all the way to Burns, Oregon, in the summer. Again, I apologize for getting off script here a little bit. So I'll stop there. That's a long-winded, windy, probably not necessarily on point answer, Chair Halova. Hopefully somewhere in that was a nugget that helped or made some sort of sense.
Yes. And I think back to the merit, the points, the appeal factors, the idea is that I think getting clarity on how you can take land out or not, and there's enough, this is a case enough that it should be considered.
Commissioners, any other questions for John?
And I don't know if this is for, I don't know if you can answer this, John. I was intrigued by, Mr. Katzaroff's comment, how this has been taken out of farm deferral. Did you hear that too?
Thank you, Commissioner, Commissioner Warren, Commissioner, I did hear that. I don't believe, I believe that's exactly right. I don't believe the property is receiving farm tax deferral. I don't know why that is. You know, I think in some counties, counties are a little less diligent about policing that. Some counties are more or better at identifying properties that should be receiving that farm tax deferral or not. So I don't know if it's a case of, you know, non-farm dwelling approval, which may have occurred on one of the pieces and that was required to be removed, or whether I'd be surprised if the applicant voluntarily removed, you know, it's a pretty big pill there. Or whether it was the county recognized, well, you know, these guys really aren't making an attempt. They're not attempting to farm a ranch for profit. And so we're just, you know, until they do and demonstrate that they do, we'll go ahead and not afford them the, you know, luxury of farm tax deferral.
Yeah, and I think you have to not farm for 3 years on it to lose that. So that's interesting.
Yeah.
Any further questions, commissioners? Okay, so just a reminder, you know, what we're deciding here is those 6 different factors. Has the staff brought forward enough evidence for you to support one or all of those, or a combination thereof? And would anyone care to make a motion at this point?
I move that the commission authorize the department to appeal the subject decision from Deschutes County to the Land Use Board of Appeals based on the information included in this report and its demonstration that ORA 660-001-0230, Section 3, subsection A, B, and E apply. Am I reading that right? And E? Okay.
I'll second.
Any further discussion? Can we call the roll, please?
Commissioner Lazo has an excused absence. Commissioner Sandoval,
Aye.
Commissioner Jacobson,
Aye.
Commissioner Boyer,
Aye.
Commissioner Warren,
Aye.
Chair Halova,
Aye.
and Vice Chair Lelak has recused himself for this item.
All right, motion passes unanimously. Thank you very much, Sean.
Thank you very much.
Thank you very much, Commissioner. Director, you want to call Mr. Lelak back? Take a 15-minute break. Okay.
Okay.
At this point, we're going to go to a 15-minute break. So we'll be adjourning at 3:30.
Oh, yeah. Yeah.
Ready? Welcome back, everyone. Following our break, we are now moving to agenda item number 9, our climate-friendly and equitable communities program update. I'm happy to turn it over to our team.
Thank you, Vice Chair Lilac. My name is Bill Holmstrom. I'm the Agency Land Use and Transportation Planning Coordinator. And joining me today is Evan Manville, Land Use Transportation Planner. He'll be joining me here. And also virtually, we'll have Cody Meyer, another Land Use and Transportation Planning here, planner here. And all three of us will have a piece of this presentation. I do want to recognize in the room, we have Kevin Young, who our Senior Urban Planner, who's also is an integral part of putting the rules together and implementing them as well. Yes, I get to button here. Okay, so today we're just going to go have a few quick pieces here. We'll give the commission an update on how the program is being implemented so far. A quick update on the Every Mile Counts initiative, which is the 4-agency joint program that this is all part of, working together with other agencies to move forward on implementing the statewide transportation strategy. And then we'll talk a little bit about staff's recommended approach for moving forward with potential amendments to the rules that you adopted last year. So we'll start with that implementation update. I'll hand over to Evan.
Thank you, Bill. Evan Manville, he, him. So we've been busy, which is good. It's good to be at this part of the CFEC program. We have been busy trying to help our local government partners implement this program. To start, we've been providing a bunch of publications and guidance. I wrote in this slide many publications on climate-friendly areas. We've got 5, and we've got 12 on parking reform because I can't shut up about it. We also, every day, both our team and our regional representatives are helping local government planners and other folks consulting and saying, this is what the rules mean, this is how we can help you implement them, that sort of thing. And then we're starting to see a bunch of code updates come in. Communities are updating their codes, and we're reviewing those to make sure that they are in line with the rules and providing suggestions on how to improve them, that sort of thing. We also have regular monthly office hours. We're starting to co-host those with our ODOT partners because some of the questions are directed towards ODOT's parts of things that they're helping implement. So those are on a monthly basis. People show up and ask us their questions, and we provide a little bit of update, but it's a pretty open conversation. And we're starting to have some peer exchange meetings, particularly with the climate-friendly areas designation. There's some peer-to-peer questions between the Council of Governments doing the analysis for us, the local cities, and saying exactly how does this work, that sort of thing. So people sharing ideas and thoughts back and forth on best practices there. The first step in the rules, or the first thing to take effect in the rules really is the parking reform, what we call Parking Reform Part A. That went into effect starting January 1st this year. So about 1 million plus more Oregonians live in places without parking mandates as of January 1st. There are also some things that happen jurisdiction-wide in the CFEC communities. There are no parking requirements for equity uses. You can see on the slide, it's things like affordable housing and facilities and homes for people with disabilities and very small housing units, childcare facilities, that sort of thing. We're just trying to help people who are trying to develop these, cut some red tape. As part of Parking Reform Part A, multifamily parking mandates are capped at 1 per unit. People can build more, but cities can't require them. And then one of the biggest impacts is no mandates near frequent transit within 3/4 of rail stops, 3/4 mile rail stops, and 1/2 mile of frequent transit lines. What that looks like visually is, for most cities, a majority of the city. This is Ashland, for example. It's about 80% of the tax lots are within a 1/2 mile of line 10. Correct me if I get that line wrong, Bill. Yeah, okay. Yeah, and so similarly, Oregon City has a map like this, cutting through, capturing its downtown and a bunch of it. Salem and Kaiser and part of unincorporated Marion County are on this on the map on the left. Gresham, all those areas in green, and really bright green on our screens, are there. So you're really seeing a lot of communities cutting the red tape on parking. The next step on parking is what we call Parking Reform Part B. That's due by the end of June or an alternative date. And that has to do with some wonky things about parking lot design and shared parking and parking maximums in larger cities. And there's some additional provisions. And that's also when we ask communities to have made a decision on which of the three reform paths they're going to take. One, which is repealing all parking mandates, to the fair policies approach, and three, kind of reducing a bunch of mandates in types and areas, as well as doing some unbundling. This slide doesn't read that well, but we're seeing local governments try to making these decisions, deciding what to do that works for their community. Most are choosing option one, no mandates. That's for obvious reasons. If a lot of their city already is headed that way, it's kind of administratively easiest just to do that. Some are exploring option three as well. So we're seeing that. We're also seeing cities move at different paces. Some, like Corvallis and Tigard, have already repealed their mandates citywide. City of Bend is partway through that, should take effect at the start of March. Beaverton's coming along, and others. So we're seeing a lot of those kind of faster moving cities take that and get that implemented. And we expect many more will this spring. Others are taking some more time to think about it, and they're requesting alternative dates. Bill will talk about that some more. But yeah, we're just seeing communities do different things. The last note, as we noted, was as we were adopting the rules for parking A, people could apply the state standards directly or amend their codes. And cities have done different things on that. City of Salem amended its code. A lot of cities are just providing guidance saying, hey, this is the state rule, to people who are coming in asking about it. So that's where we are with that. The other big piece that's early on in the CFEC program calendar is climate friendly areas designation. We are providing over $800,000 of assistance to our local government partners who are tasked with this, both the technical analysis piece of it and community engagement. There are 15 communities we're working with, and we've started to have some community meetings out there. Corvallis, Albany, and Philomath, upcoming in the next couple of weeks, Southern Oregon and the Northern Rogue, and then a little later in February, Salem Kaiser. So we're starting to let the community know that this is coming, and people are calling them different things. Some call them walkable mixed use areas, WAMUAs, because they have to call them something. But yeah, we're really working with local government partners to figure out where these might go and how big they should be and where they want them. So that's a healthy conversation. We're engaging equity partners as well as part of that community engagement to kind of try to make sure that their voices are centered early on in the process.
Thank you, Evan. So I'm going to talk a little bit about the alternative dates process that the commission put into the rules that allows local governments to ask for some different timelines for certain pieces of these rules. That parking B that Evan just talked about is kind of the most popular one that folks are wanting to push back. So far, the director has approved 2 jurisdictions for some alternative dates: the cities of Eugene and Lake Oswego. We have a number of other requests currently pending at the agency right now. There's 8 as of this morning. As you can tell, our deadline is January 31st, which is next Tuesday. So they're starting to come in a little bit faster now. That is the deadline for most jurisdictions. I just want to be clear that Eugene, Springfield, and Salem Kaiser areas, because they're going to be doing some additional regional scenario planning work, we gave them some more time to do the alternative dates, to work those in along with the regional scenario work plan that they need to do by this June. So they've got a little extra time still. As you can tell, the city of Eugene wanted to get a head start. They asked for a date already last year to do something. So we were able to prove that. City of Salem has done something similar, and they've submitted a request. But that doesn't mean that they can't still bring in something in with that regional joint work program. The other piece that we have are exemptions, and these are mostly for smaller jurisdictions. And they're actually all the ones we've granted so far are entirely smaller jurisdictions where we can grant, the director can grant a full exemption from any part of Division 12 or just from a part of the division. And these are all kind of all over the map in terms of what they've asked for, what they've received, and how long those exemptions are for. They're all temporary. And you can see that we've got 7 jurisdictions so far. There's Rogue River asked twice for 2 different things, so they've actually got, there's 8 total exemption requests. There's no deadline for these. They can ask at any time. This is really a carryover from the existing rules, which had this provision for small jurisdictions in it already. So it's been in there for decades. So it's very similar. One other piece that we did add to the rules this time around was we let jurisdictions that are newly within a metropolitan area, or a new metropolitan area is created, and all of a sudden there's jurisdictions that are these rules apply to, we let them ask for an exemption for a period of time anyway, just to get their feet wet and to kind of like also have to do what. And it looks like the Census Bureau just this last week, we got some information that there may be a handful of jurisdictions that are going to be brought into either the Salem-Keizer or the Portland metropolitan area. But that's not final yet, so I don't want to say anything, but that's my understanding just from what the Census Bureau has sent out there. So now I'm going to hand it over to Cody. And Cody, you just let me know when you want me to move your slides forward. Cody, are you able to?
Thank you. Sorry, someone had to unmute for me. Apologies there. Thank you, whoever has mute control. Thanks, Bill. For the record, Cody Meyer, I'm a land use transportation planner with the department. And I'm going to give you a little overview here of what we're working on the scenario planning work. As you recall, the rules you adopted in Division 44 require 3 different regions in the state to do the regional scenario planning work and come up with a regionally preferred vision to meet the Division 44 greenhouse gas reduction targets. Those areas are the Portland metro area. They've been required to do this work since 2011 with the initial rule adoption for that division. Then it's Eugene, Springfield, and Salem-Keizer. And we have done ongoing work with Eugene Springfield. In 2015, they brought in a scenario to the commission that they did not have to adopt or implement, but they did significant work there in 2015. The rules we adopted said, you can use that scenario, but we're going to have to do some implementation work on that and show how we'll implement that scenario. So ODOT staff and is running up some contracts to support the Salem-Keizer Eugene Springfield work. Salem-Keizer would have to start from afresh. So ODOT's been working really hard on getting those contracts out and has pretty close to releasing some consultants for that work. Staff is working, I think, really diligently with the Portland Metro staff as they do an update to their climate smart communities and their regional transportation plan. That'll be looking at an update to see how they're doing with the targets and doing some implementation monitoring. In the other areas, where the same contract with ODOT is going to be looking at getting support for setting performance targets that are calibrated to the statewide transportation strategy. So that's kind of a default scenario process that they go through. So we've been working really hard to get the regional work programs up that Bill spoke about to make sure that they're really thinking through the scenario work and the Division 12, how that fits together, working with all the different contracts that'll have to support all that work. And then we'll be kind of rolling that out, I think, probably later this year, we start seeing some work there. So next slide, and I'll pause. Is there any questions on our kind of implementation update that we had? And if not, I can go into the Every Mile Counts update.
Please.
You should have ran back. No, I'm kidding. So your office hours, are they set? Because I've had a couple people ask about, outreach and not outreach, but just
Yeah.
that type of scenario? Is it a set time? and date?
It varies from month to month to provide different opportunities for people. So yeah, we have one scheduled for February and one for March. I can look up those times and dates.
Okay.
People
Where-
who
where
get
could
our
somebody go-
email newsletter. The thing we didn't have was the regular gov deliveries that we send out announcing all these things.
Okay, so
Uh,
gov delivery. Okay.
So
People-
we
peop-
have
people have
1,300
asked.
people or so on that gov delivery list. So.
Okay. And then that map of Salem Kaiser,
Uh-huh.
there was just like there was a blob in the middle. I'm trying to figure what,
Yeah.
just, I don't know. It seemed odd.
Yeah, so you could ask someone who's on the Chariots board why that, no. We've got two in the room. But yeah, those are the frequent lines that go 15 minutes or better in the region, and that's how our transit. So I don't know if you want to add to that.
Yeah,
Bill?
Chair Lee, like Commissioner Boyer, there are a couple lines actually that do run through there at half-hour intervals, so they don't hit quite that target. But mine was it 13 or 3, I think, and double up out to Silverton Road, and then they split up. So
Okay.
you do have service through that area.
Okay, just seemed weird on that map. Do I? On the exceptions, is there a length of the exception?
Chair Lee, like Commissioner Boyer, yes, each of those have a time frame attached to
They
them.
do, okay.
They're different time frames for each of those. Some of the shortest ones, I think, were just 2 years, I think is the shortest one we did. And then the longest ones were 10 years,
Wow,
Yeah.
okay.
but for really small cities.
And then before you move on, any surprises thus far?
Saying that. I'd say there's lots of little things, certainly, Commissioner Boyer, that have popped up. But you know, big surprises. I don't think there's anything that's really been super concerning.
Okay.
Or that was unexpected. And what do you think?
Yeah, there's nothing that, I mean, we spent a couple of years on it. We kind of knew that some things are going to be more difficult and some things are going to be cleaner. And so that's what we're trying to work through.
Thank you.
Yeah, good. Thank you. Commissioner Warren.
I just have like more of a technical question. So when I look at this, especially the map of Salem Kaiser, I'm wondering how applicants who live in or near the area know if they're in that half-mile radius or not. Is that being included in zoning plans, or that's another way to measure?
Yeah, thank you, Commissioner Warren. So generally, there's a map at the development counter for people when they come in, and it's, as I said, the city of Salem has it in their code. And so what we've suggested local governments do is provide a map and say, if you want to appeal, whether you're within a half mile of this, or provide evidence that you are within a half mile of this, that's something the city would consider. So there's kind of a 99% of people can glance at that map and know whether they're in or out, and the others can argue if they want.
Okay, great.
Or provide evidence, yeah.
Thank you. Any other questions or online, Chair Halava or Commissioner Jacobson? Not seeing any questions, so please proceed.
So back to Cody. Okay, thank you. It's kind of tough with the mute lock there.
I am seeing that Chair Halova and Commissioner Jacobson have their hands raised.
Oh, they do both. Oh, good. Okay, great.
Yeah,
Let's-
and I'll just flag, we can't unmute ourselves. It says that the host has to do it for us. So that's gonna, just something to look out for.
Is that the case with Chair Halava? as
Yeah,
well?
that was the case.
Okay.
It's like, can't talk. I just want to congratulate the team for moving forward with the work. It's exciting because I feel like we've been talking about it for a while and now moving forward, and then the being open and receptive in the office hours. I think this is a evolving process, and I'm happy about the commitment of the department to view it as such. Thank you.
Thank you. And Commissioner Jacobson also had her hand up. Is that correct? Yes.
Yeah,
Just-
thank you. I was mostly just trying to say I didn't have questions and then I couldn't talk, so. I just wanted to make sure we got the muting issue dealt with. Thank you.
Thank you. Yeah, we don't have your you on the screen, so I'm relying on Jan to let me know if there's a question or not, since I keep asking. So with that, Commissioner Sandoval.
Yeah, so I was looking at the guidance publications that are online, and I was looking at that really good overview, 6-pager of the entire rules. But the equitable outcome statement, that link is broken to that.
Thank you for that flag, Commissioner Sandoval. I will not try to fix that during this meeting, but right afterwards.
Any other comments or questions? I'm not seeing any.
Yeah, thank you. I'll hand it back to Cody.
Thank you, Bill. Okay, so as Bill mentioned earlier, the CFEC program is a part of a larger effort on the state's part to get the state back on track with achieving our greenhouse gas emissions reduction goals from the transportation sector. And that's through implementing the statewide transportation strategy. This effort has been branded as Every Mile Counts. It's our agency, Department of Transportation, Environmental Quality, and Department of Energy. We started coordinating on this work probably in 2019 and have signed a memorandum of understanding that is at least a 10-year commitment. We do rolling 2-year work plans. We have implementation teams, so actions that we've identified have to be cross-disciplinary across the 2 agencies. So just want to be clear that this isn't everything the state's working on in climate change or even transportation climate change. It's ones that we feel that can really benefit from working across agencies and doing more strategic planning on. And so we have ongoing meetings at staff. Directors of the agencies are meeting quarterly. We have accountability, and we really center the engagement on this through an equity lens. Next slide, please. So at that point, we with the original work plan in 2020, we held a series of equity workshops, and out of that developed equity guiding principles for our actions and equitable outcomes for our actions. And that has guided the work to date. We recently, since the 2-year work plan kind of expired last year, staff and the directors have been working on creating the next work plan. Much of it is just implementing the first ones. There hasn't been a drastic change of actions. So we didn't go back and do equity workshops, but what we did at this juncture was we did some equity crosswalking. So we took the principles and actions from those workshops, and we did, as Commissioner Sandoval, you pointed out, we have an equity crosswalk for CFEC. We have a similar version for this work. And what we did is we said, okay, here's what you told us you wanted us to focus on. And so here's what we did in the last 2 years to get to those outcomes. And so we provided that, and we went back and circled up with our partners that attended those workshops and gave them presentations and solicited feedback on how are we doing, and are there things we can do better to get to more equity in transportation emissions reduction actions. Next slide. So this is the key objectives for our next work plan, and they really reflect what's referred to as the 3-legged stool to reduce transportation emissions. There's 3 things you can do. You can reduce the amount of miles that are driven. You can clean up the fuel content and kind of decarbonize as much as you can the fuels that are being burned. Or you could switch to something like electricity or hydrogen and really get to more of a 0 emission fuel. Throughout these objectives, we are really integrating climate justice and equity considerations. Next slide. So this slide really just shows you on the 2 columns of what we're doing in the 2022 to 2024 actions compared to the middle column being the original work plan from 2020 to 2022. You can see on the bottom row, we have climate-friendly equitable communities implementation. We moved from rulemaking focus, where we worked for over 2 years, as you know, on getting rules up and adopted. Now ODOT and DLCD are primary partners to make sure that we're implementing those rules. So as you all know, we've between the two agencies secured nearly $19 million to support implementation. DLCD has a budget request out now in the session for $12 million more to support local jurisdictions in that work. And as you just heard in the previous item, we're working hard and getting those rules updated or getting those rules implemented. So some of the other stuff ongoing is commute trip reduction rulemaking up at DEQ, expanding the clean fuels program, again with DEQ and LEAD. Then a whole lot of work on electric vehicles and charging infrastructure. And that's primarily an ODOT, DEQ, and ODO partnership. To support all of this, what will be coming out, and I would like to get your information there for you, is that we're creating a transportation emissions dashboard to have transparency and like kind of performance management on what are the actions necessary to achieve our goals as a state across state, federal, and local actions, and where are we at? So really doing a lot of performance tracking and monitoring. And that way we can see where the gaps are and it'll help drive our future work plans. So that should be coming out in the next 6 months. With that, I'll pause, and if there are any questions, or we can move to the next item.
Commissioners, any questions in the room or online? Chair Holova or Commissioner Jacobson?
None for me, thanks.
None for me.
Thank you.
Thank you. Yeah, thank you, Cody. So I'm going to take it back and just finish up with talking a little bit about potential amendments to the rules moving forward. So when you adopted the rules last summer, one of the things that you directed us to do is to keep track of the issues and how things are going. You know, obviously with, I think, a rulemaking of that size, it wasn't going to be perfect from getting out the gate. So we tried as much as we could to do that. And of course, we did a lot of iterations, but we knew that there would be some issues along the way. So we've continued to, as you heard earlier, work toward implementing a lot of these, all the rules. We've addressed many issues through guidance where a rule is a little bit unclear or something like that. We're able to put guidance out there, say, this is what we meant when we were doing this. This is the way we think is the right way to implement this part of the rule. We're able to do that. But, you know, I think there's just a few things here and there where I think staff would recommend some limited corrections and clarification amendments. So that's what we're bringing to you to talk about a little bit today. So our recommendation is to just look at a set of amendments that's just minor stuff, just corrections and clarifications, nothing that really requires a depth of policy judgment or really changing how outcomes are going to happen or processes even within the rules would happen. Just mostly minor things just to clarify. And we had some examples in attachment C to your staff report. And then, so our recommendation for how the process would work on this is over the next few months, our staff would solicit public comment. We have a list of ideas that staff's come up with, and a lot of that have come up because we've had conversations with local governments that are actually on the ground trying to do this stuff. And what does this mean? What does that mean? And it's like, okay, well, we need to fix some little pieces here and there. But we still want to make sure that we're casting a wide net, so that we're going to go out and solicit additional comments over the next few months. Then after your April meeting, and ideally you'd say at that point, yes, go ahead with this set of amendments. We would convene a small advisory committee, not to the scale that we had for the full rulemaking, mostly focused on folks that are working on implementing these rules, and probably wouldn't have to meet very many times, once or twice, to review those proposed amendments, and we bring proposed text to them. And then hold a set of commission hearings at your final 2 meetings of the year in July and November. It says October in the staff report. I apologize. So then the adoption would be in November of this year. And that's about as quickly as we could reasonably do this based on your schedule and based on just the rulemaking rules and how that works, and doing it in a process that we felt was going to be open and available to folks. Work. I'm not able to advance. Oh, there we go. Okay, thank you. So again, this would be minor clarification and correction amendments only. There are some examples of the kinds of things we're looking at in attachment C, just real high level. Some of the examples of those things are just making sure that we're using terms consistently and using consistent terms throughout the document within each rule and then also across the division. Clarifying just a few provisions that are maybe just a little bit unclear or inconsistent. And then fixing there's some errors. There's like one numbering error we found and a couple of little things like that. Again, not for the larger issues requiring policy judgment. But moving forward, we understand that there may be a few things that are not at the level of overhauling what we're trying to get at, right? You know, we all have the same outcome in mind, but there may be different ways to get to those places, some processes or you know, just ways of structuring the rule that might require kind of that middle level of efforts to take a look at. And staff's come up with a few ideas for what kinds of things might go in there. And when we go out to the wider public to get feedback from folks, we expect to hear, you know, things that will fit in that minor corrections and clarifications, but expect to hear lots of other things as well. And so we expect later this year to bring an idea to you that would be kicking off another process that would go into 2024. That would be a little bit more extensive, probably again, not to the level of the detail and you know, the size of the committee and the number of times we meet of that first rulemaking process that we went through last few years, but more substantial than just those minor corrections. So we've kind of split it up just to get kind of some of those little things out of the way, and then we can kind of have a committee that sinks its teeth into a few more meaty things. But again, we're not trying to adjust the outcomes here. We're trying to make sure that we're getting to those outcomes in a way that makes sense for folks. So I think with that, that's the end of our presentation. I'm happy to answer any questions or have a conversation with the commission or receive any direction. Thank you.
Yeah, great. Thank you. I'll certainly have a couple comments and questions, but I want to look to my colleagues first. Commissioners here or online. Chair Sandoval, or Commissioner Sandoval.
Oh,
sorry.
man.
I was looking at the screen and handing you the gavel.
No, I agree with you that it's nice to be in this, you know, at this time, actually being flexible as well. And so I guess I don't know if you thought about this, but especially for like smaller cities, I'm wondering if we can choose some sort of like pilot, you know, have like an exemplar kind of city, you know, where we put our efforts into and our focus on, so that then the other cities can kind of learn from them. And I'm thinking of like maybe cities that are, you know, 25,000 or so. What do you think of that idea?
I don't know, Evan, do you have anything?
No, I mean, it's certainly that's something we do with the code pieces, but am I understanding the idea that we invest more resources and really try to make bring it? We are working across state agencies to bring other resources to make the developments happen after the planning happens, working with Housing Community Services and Business Oregon and ODOT and all our partners. But we have not, as a cross-agency collaborative, decided to target a couple of communities. But it's a nice and interesting idea, and one that we could discuss with our peer agencies.
Yeah, and I'll just follow up on that real quick, Chair Lilac, Commissioner Sandoval, that, you know, I'd say, you know, in terms of the implementation activities, I'd say there's a variety of communities that are, you know, ahead of folks and are really, you know, kind of pushing forward and being, you know, making positive changes and you know, really taking the rules to heart and moving forward with them successfully. And there's a number of those communities around, and that's been really good to see. And each of them are handling things a little bit different way, or maybe putting a focus in a different part of things. But we're already seeing a lot of, you know, jurisdictions that are doing great things around the state.
And we are trying not to reinvent things. Like the city of Wilsonville had a great parking handout, and we said, hey, everyone who's trying to do a good parking handout, here's an example. So we're trying to make sure that local governments don't recreate things that are already being done well.
Yeah, that's great. Other comments, questions? Commissioner Warren, geez. Yeah.
I just want to say thank you to all of you. I know that's been a huge lift on your end. And I just appreciate all the work you've been doing. And I'm really happy to see that you're continuing the thought process to, how can we make these better and continue to improve them? So thank you.
Thank you. Comments or questions online? I will, Chair Halava or Commissioner Sandoval or Commissioner Jacobson.
I
Any
have
comments?
no comments. Supportive of what everybody else said.
Same for me. Thank you.
Thank you. I just want to say, to me, this is exactly the process that I hope we would see going forward post adoption to listen, to respond, to address the issues that come up through implementation. And to me, this demonstrates exactly that commitment. It'll be interesting to see what we hear, what you're already hearing some things. And I think as the program moves forward, we're going to continue to hear more from our local government partners that are going to be on the front lines implementing this. I certainly appreciate that you're going to have an advisory committee to take a look at the package as that proceeds through. And the timeline is also just interesting in terms of convening the advisory committee through June. And we know what also happens toward the end of June is the legislature will complete their work, and we'll see if they have any adjustments in the program for us to also consider at the same time. And certainly I expect the department staff will be monitoring those and weighing in and participating in the legislative session and process as necessary with that. So I think it's really great work to this point. And what we look forward to doing next here in just a moment is opening it up for public comments. And we want to take a break now and recognize.
I think we have the senator on the line. We should probably.
We'll take that moment now. Yeah,
Yes.
perfect. Thank you. Available online right now. So if Jan, if you can allow Senator Solomon in, that would be great. We certainly look forward to the senator's comments. Welcome.
Thank you so much for this opportunity. It okay for me to proceed?
Please, welcome.
Wonderful. Thank you. Chair Halava and members of the commission, for the record, I'm Janine Solomon. I'm an Oregon State Senator representing Senate District 15, which includes the cities of Forest Grove, Cornelius, and Hillsborough. Now, I stepped out of committee for just a bit for this opportunity, and I really thank you for this time to speak to you. My purpose in this public testimony today is to share your commitment and your urgency to mitigate the impacts of climate change and to close the equity divides that continue to exist between our communities. Because I care about these issues, I urge you to listen to local governments about the challenges that these rules present as currently written, which do not allow them to advance the goals and objectives of the governor's executive order. Instead, the rules are so prescriptive that communities like Cornelius and Forest Grove and Hillsborough will be forced to create more inequities and plan developments that end up actually creating more GHG emissions, not fewer. So I understand the pressures, and when many stakeholders are coming at you and are at the table with varying perspectives, I also understand that when making policies, or in this case, in rules, as we do in the legislature, we base that off of the best information possible. So however, when new information is available or the impacts of the policy result is unintended consequences, leaders must take the time to really amend what is not working and make sure that we're getting it right. So I urge you that as those in leadership roles, as yourself, as you take this opportunity to not only really listen, but to go out firsthand and see the impacts that these rules are having on our city's ability to meet the needs of our residents. We have legislation this session. It's to direct the agency to fix these fixes. But as a legislator, I can tell you that the first thing is to say that legislation and legislating is not the fix that is ideal. So in fact, it is far from ideal. And so there are so many other issues that we must be addressing, and this one actually does not require legislation, but actually can and should be handled administratively. So this must be done so, and with the urgency that it demands, given the deadlines for our communities to comply with unworkable rules, because ultimately we as legislators, we have the responsibility to our constituents to fix these issues legislatively. We are hearing from them. So please, as a service to our state, exercise your authority to amend the rules in a timely way with meaningful input from our communities that are critical for this work advancing. So you'll hear some of the examples of the challenges on the ground from others, I believe, today. I'm not sure that if they have gone before me. As I mentioned, I dipped out of committee, but I hope you'll really listen and recognize that not all communities in Oregon fit the same exact mold. So I'm certain that they could field any questions that you may have going forward. But my hope is that we can all move in the same direction with the same goals and the vision, if the rules can be flexible enough to honor our differences with how we meet those goals. So I really sincerely appreciate your time today. And I thank you. And this concludes my testimony.
Senator, thank you very much for joining us and stepping out of committee. Your comments are really, really important. And I thank you very much. I work for a local government, and I completely agree that we have to listen to our local government partners to make sure this is a successful program. I really appreciate your taking the time. Do you have a moment in case a commissioner just has a brief comment or question as I know that you need to return to committee?
I'm actually chairing this committee.
Oh, I'm sorry.
So if I am certain that questions, I certainly welcome any feedback, and we can talk on the phone if folks want to ask any questions, but I'm certain that other folks that are testifying could answer any questions. And if not, let's touch base.
My apologies. Thank you very much.
No worries. Thank you so much. Appreciate it.
We want to accept other public comments at this time, or should we return to staff to continue?
If there's more to the presentation, we can return to staff. But I don't know. Okay.
Is she available? Oh, great. Ariel Nelson, I understand, is available. So Ariel, we welcome you to our meeting and we look forward to your comments.
Thank you. Can you hear me okay?
Yes, thank you.
Thanks. I'm also in the Capitol and stepped out of hearings. Thank you so much for having me today, Chair Holova and members of the commission. For the record, my name is Ariel Nelson. I'm here on behalf of the League of Oregon Cities and the local governments working with DLCD on the implementation process for these rules. I appreciate the opportunity to address the full commission today. I hope to use this opportunity to try and reset the conversation and chart a path to meaningful collaboration that allows local governments to meet the needs of their communities while advancing the important goals that the CFEC rules aim to address. The topic of the agenda item identifies that there are challenges and that the rules need amending. I understand that there's no plans, however, to make significant changes until potentially 2024. While pending litigation and legislation are introduced to address our concerns, we would rather work with you and the department because we're aligned in the outcomes. We remain aligned in the outcomes. However, there are serious obstacles because of how prescriptive the rules make implementation impossible for some communities, or have the opposite impact of what we all want, such as more greenhouse gas emissions or greater equity gaps, not fewer. Important deadlines are upon cities now to comply, and there are still many outstanding issues that need to be addressed, not only on the immediate parking issues, but also in the long term. Before I offer some concrete examples, I also want to point out that the cities do not want to delay and share the same urgency to address climate and equity in their communities. Cities also only have so much capacity to continue to work on the rules with the department to fix what is broken while also trying to meet deadlines, so their legal liability isn't exposed. While pause may be interpreted as a halt of all work, that interpretation is false. Cities and counties need the flexibility to inform and help address the issues if the department is truly committed to listening and working with us without added pressure of trying to comply with rules that don't work. And so I do want to offer some concrete examples to further illustrate what we're asking for. So in Springfield, the city has been working on expanding housing options for people with disabilities. The city repeatedly shared concerns that the CFEC rules prohibit the city from requiring ADA accessible parking. After many exchanges and conversations with the department, the agency acknowledged that this issue is a challenge and a problem. In its implementation guidance, the department suggests the city require on-street ADA parking instead, or encourage developers to provide off-street ADA parking anyways. To be clear, on-street parking is woefully inadequate for people with mobility limitations. It is also unrealistic to think that developers will provide parking they are not required to provide, which the rules prohibit cities from requiring. The city met with the department and with the Building Codes Department on November 16th, at which it requested legal guidance on its ability to require ADA parking. And the only solution offered was that Springfield could require one single ADA space for a development of any size. A single ADA space in a multiple unit housing development is not going to meet the needs of Springfield residents with disabilities. This creates hardships for the residents that need the most help. In Cornelius, CFEC rules prohibit the city from requiring parking within 1/2 mile of a bus line. But for Cornelius, that results in prohibiting the city from requiring any parking because nearly an entire city is within 1/2 mile of the single bus line that serves it. The single bus line is important, but not an exceptional transit service. And the inability to require parking is a problem. The 2 park and rides are on Metro's financially constrained regional transportation plan are also not the answer for the residents of Cornelius. The city's demographics are such that many residents work multiple jobs, most of which cannot be done from home. A single bus line is of little assistance unless you live or work along that bus line, and most city residents do not. The contrast between the lived experience of Cornelius residents and the department's conclusion was highlighted during the development of the rules when the city council invited the department's area representative to attend a city council meeting and hear the city's concerns. The regional staff declined because they live in Portland and don't own a car. Therefore, it would take them 2 hours to get to Cornelius on public transportation. And by the time the meeting ended, the bus service stops running, so they would not be able to get home. According to the department, this is an exceptional service line. In Happy Valley, the CFEC requirements adversely impact mobility for lower income families. 1/3 of recently built developments in Happy Valley provided only the minimum number of parking spaces required. Many of these developments are multifamily complexes, some of which are not in the TriMet service boundary. Eliminating parking minimums will impact those living in multifamily developments the most. Many multifamily developments do not have nearby on-street parking or contiguous safe sidewalks between the multifamily development and a place to park. In the future, community members living in these developments will be forced to walk in unsafe conditions to find legal on-street parking. This is a serious safety concern that is likely to be quite common for developments on the fringe of the metro region. It also disproportionately impacts lower income families where parents are forced to balance commutes to 1 or more jobs, kids, or other obligations. Happy Valley does not have frequent transit available in much of the city. Until that is a reasonable option, the city has a responsibility to provide safe and accessible ways for families to get to and from their work, the grocery store, school, etc. As the rules stand now, there is not enough flexibility for the city to do so, and it's harming those families who need more support, not more barriers. So these are just a few examples, and many more like this continue to be uncovered as we move through implementation. The statement is not a criticism, it is a fact. Some areas we previewed and new ones continue to evolve because these rules are new, which is part of the process. As such, making improvements and adjustments should also be part of the process. So while we appreciate that there are discussions in the department about addressing these and other areas that need amending, some of the deadlines we face are urgent. We do not have time for a year-long process when the clock is ticking. And that same clock is ticking on the urgency of equity and climate change in our communities. We hope that the commission will take these comments as a commitment to the goals of CFEC and a shared sense of urgency on these issues, and that you will join us in understanding how different each community is and why the prescriptive nature of the rules must be more flexible so they work and help all communities thrive. Thank you again for this opportunity.
Thank you, Ariel. Thank you very much for your continued participation in this throughout, and your commitment to the CFEC program, and to helping to do everything possible to make it successful, and for sharing these specific stories from across the region. I certainly appreciate it. And I think, we're going to begin the process here through February, as I see on the calendar, to solicit comments. And I certainly hope you and other local governments will participate in that process. And I know you stepped out of a committee hearing as well. Do you have a moment if Commissioner has a question or comment to stay online with us for a moment?
Yes, I have a few minutes. Thanks.
Great. Thank you very much. So I'll look at.
I have a question.
Yes, please, Chair Halava.
Oh, yeah. I was curious, Ariel, in all of these discussions, whether there was talk about incentives for developers to build versus requirements to build parking. Because from the development perspective, a lot of developers I know are actually very responsive to the folks that they want to live in the buildings, because if they can't provide what's needed, then they won't be able to fill their building. And so I was curious, there's two ends of this. One is mandates or requirements, and the other one is incentives. And I wanted to see if there were conversations on incentives, be it, there's a lot of potential incentives, but, density or so many things that could be incentivized.
Yeah, I appreciate that question. I think that cities definitely view incentives as really important tools for this. My understanding is that the prescriptive nature of the rules really limits their ability to do so. And I'm not sure that for some of these things, based on their experience, I don't know how impactful incentives are for any given measure. So I don't know that it's equally, as impactful, right?
Thank you.
Thank you. Any additional commissioner comments or questions? I'm not seeing any. Ariel, thank you again very much for joining us this afternoon. We always value your comments. Thank you very much. Are we now at the, do we have somebody else online? We do. Great.
Yes, Matt Brinkley.
Great. Welcome. We look forward to your comments. So it's hard for me to see. I see Matt as the first name and Brinkley. Is that correct from the back? Great.
That's correct.
Welcome.
Yeah. Thank you, commissioners, and happy to have the opportunity to kind of update you on the implementation of CFEC here in the Rogue Valley, and specifically the city of Medford. I'm the planning director here, was an alternate on the Rules Making Advisory Committee. And I just wanted to update you on what's been happening here and challenges that we're encountering, as well as, maybe some good news. So we completed parking A by December 31st. So we're on time for that. We're working on parking B right now. We will be applying for an extension. In fact, I think Dr. Bates, if you look in your inbox, you will find that request for an extension for several different parts of the rule, specifically 425(4), that's the unbundling requirement for parking. We have some concerns about how that will actually work, and hope that staff will continue to provide guidance about how that is going to happen. We think it is potentially quite problematic. The timeline for parking districts, we also think, is way too short, so we'll be asking for an extension on that as well as a little more time to hopefully engage in a conversation with our community about potentially removing minimum parking requirements citywide. But we're not going to get that done by June 30th. And so we hope that we will have a little extra time to have a meaningful conversation with all of our partners here and decide whether or not that's something that we're going to do, or if we're going to go the other route. Other topics of concern that I hope you will continue to explore are resources for ensuring equity in CFAs. We have the anti-displacement data, but that doesn't mean that once we encounter those situations, that we have the resources to address displacement caused by gentrification. So I hope that as you're making recommendations, policy recommendations to our legislators, as they go into this session, that you're advocating strongly for the resources that local communities are going to need to be able to avoid or mitigate the impacts of displacement caused by gentrification and CFAs in the future. With that, we have some other issues, but I can report on those at some time in the future. So thank you.
Thank you very much, Matt. And I want to turn it over to commissioners for comments, but I also want to welcome you to our Grants Advisory Committee as we approved our motion this afternoon. So we welcome you to that new committee with the DLCD. So with that, commissioners here or online, questions, comments for Matt? I'm not seeing any in the room. Do we have any online? I'm not seeing any. So Matt, thank you very much. We really appreciate your comments and your joining us this afternoon.
Thank you.
No other comments. Does that conclude our agenda item this afternoon? If that concludes our agenda item this afternoon. And again, I just want to just conclude by thanking staff for the update. A great update, a lot of great work happening in the department to implement the program in coordination and collaboration with our local government partners. I want to commend you for the schedule going forward to listen to what those minor amendments may be. And we look forward to seeing those proposed amendments, at least the first draft, in April. So thank you very much to the whole team. Next step. So does that conclude our day for today? It does.
Took care of sage grouse.
Thank you.
Public meeting tomorrow begins at
10:15.
10:15, the public meeting.
So, okay, so tomorrow morning's public meeting begins at 10:15. We have our executive session. Prior to that, we have a time that's
Well,
going to begin.
Yeah, I was gonna propose, since we have the time certain at 10:15, if we'd like to start at 9 o'clock, we could go something like 9 to 10, and then you could have a little break prior to starting the public meeting, if that works better for everybody's schedule.
Straight for me. Yeah.
Okay,
That
great.
works for you. So, so we'll have that from 9, just so our commissioners, our chair and Commissioner Jacobson can hear online.
Could you say that again?
Yes.
We are going to convene an executive session tomorrow morning from 9 to 10. And then the public meeting begins at 10:15. And this is because we already took care of our sage grouse issue agenda item this afternoon.
Okay, understood. Thanks.
Thank you.
Thank you.
And Vice Chair, I had high hopes that I would come down to Salem for tomorrow, but it's not looking like that's gonna happen. Just the drive alone is a little too much. So I just thought I'd ask you and say thank you for leading the meeting. Hopefully you're able to do so tomorrow.
Yes, certainly, Chair Haleva. I'm certainly happy to step in. I cannot replace you as I demonstrated today, but I'm happy to step in and serve in this role.
You're excellent. You're excellent.
Thank you. So we'll adjourn. Actually pick up the gavel. We'll adjourn for today. Thank you.
Yes. Oh, right.
I'm sorry.